matter, my lord. If it is not reached, my lord, then
Huh?
if it is not reached today, my lord, it will not before rising. If your lordship
Let
kindly.
me see. Let me see.
My lord, may be permitted to mention one matter. It's a matter, my lord, extension of interim matter. My lord, on the last occasion, my lord said inform the other part. But the thing is, my lord, nobody appeared in this particular matter.
What can be done? Nobody appeared.
So, my lord, kindly at least.
See, I told you to serve the advocate in the trial court.
Trial court, my lord.
Ah.
But I don't know. Senior, maybe senior knows. So this is.
See, I cannot go and make the service. You have to serve, you have to
Follow.
come back. Unnecessary wastage of time. Unless you serve it, see, under the provisions of Order 39, if you have obtained an ex parte order or it was passed in their absence, may not be an ex parte order. They were served, they did not appear. On the returnable date, I have to hear them. Otherwise, it becomes infraction. It becomes infraction.
Village. Today, item number this one 58, my lord.
Yes.
Regarding stay application, there is the initial stay and I have to find an application for extension also, my lord. Trial
58 in division bench.
No, my lord. My lord.
Single bench was stay.
My lord, in second appeal, my lord.
Second
Application. My lord, I have served notice also, my lord. My lord, kindly fix. My lord, initial stay also granted by the division bench. My lord, problem is no trial court executing, my lord. It will be, my lord. For this reason, my lord, you do not, my lord, kindly take up any days, my lord, this week, my lord, my humble prayer, my lord.
See, I am not so sympathetic because this must be an eviction case.
My lord.
This must be an eviction decree.
My lord.
Now, you obtained a stay. After that, you allowed
Late
this.
by my sanction, my
You
lord.
allowed the stay to be discontinued. Then what wrong is the trial judge, trial court doing in execute?
But I appeared at the time of admission.
Concurrent finding by two courts.
No, my lord, concurrent, not concurrent fighting, my lord.
But there is a substantial question of law.
What is the substantial question of?
Arguable.
What is the substantial
In
question?
the trial court, we had vote.
Yes. On what grounds? It was on reasonable requirement.
There are 2-3 grounds: reasonable requirement, notice, and the definition of tenant also.
Tenant under 2G.
Yes. But it was admitted because
what is the 2G issue?
with the 1997 Act and 1956 Act.
See, you can't be helped because I have my personal views in respect of one of the judgments delivered by the division bench. One judgment was delivered by the bench of Justice Sanjeev Banerjee sitting with Justice Sabyasachi Bhattacharya, Agarwal. And the other is Noor Hussain or something like that. No. No. Justice Sanjeev Banerjee sitting with Justice Subra Ghosh. That judgment has been affirmed by the Supreme Court. The then Chief Justice's bench, Dr. Chandrachud's bench has affirmed. See, I have a different view, and because succession under 56th Act breaks when a person dies, because succession cannot be left in vacuum. Now, in that, in the first judgment of Agarwala, you will find that the person tenant died prior to 10 July 2001, when the 97 Act did not come into it. But while passing the second judgment, the first judgment was also considered. And now the situation is that you have to relook, if you have to relook it, it has to go, I do not know, it has to go to the larger.
Only extension for the time being, that much the lordship. Because once it is admitted, stay probably
Here the tenant,
yes. He's still continuing in.
No. Original 10 died prior to 97 Act.
Yes.
You look into the two judgments.
Millard, we will. But there are other facts also, Millard, at
No,
the time
fact-
of mentioning,
see,
Millard, we are
what-
not going into it.
Secondary point of
There was a point of law, Millard, the court was satisfied, Millard, probably. We have to satisfy the lordship once again, Millard, we will. But for only for the limited purpose of extension. If Millard takes it up any day, Millard.
the division bench, while admitting the appeal, considered these two judgments.
Millard, was taken up some time back, Millard, I cannot recollect readily. Millard, I'll come ready, Millard, whatever we deferred at the time of admission, Millard, we will come back with all the judgments and.
The 2019 1 CHN 348. One CHN 348 equivalent to 2019 2 CLT 232.
Millard, I'm sorry to interrupt, but that was admitted, also that was a point, but once I go through the order of admission, Millard, it was admitted on the ground that having entered into a partnership agreement, whether that will tantamount to parting with the possession.
What partnership?
The tenant entered into a partnership agreement.
The law is very well set.
Actual control or
No, not
purported
actual
control.
No actual. Suppose you have a tenancy in your own name.
Right.
Now you constitute a partnership with him.
Yes.
If your intention is clear to create the tenancy as a partnership asset
Yes.
by bringing it in the hotspot of the partnership,
Yes, yes. Absolutely. right.
the question will arise whether it is a partnership property or it is long done.
Yes, Millard,
Or-
we relied upon Millard two decisions. And
Or-
factually, we had
or-
shown that it was only merely to borrow some
all,
capital.
all these experiments on that side I have done.
And so our time, Millard, kindly allow us to.
Oh.
Well, only for the purpose of extension, if Millard considers.
You have
Well, I'll show
What?
your lordship the judgments which we relied, and factually we demonstrated that this was not an actual partnership. In its true sense, it was only meant to borrow some capital so that the business keeps running. Other than that, Millard, there was no intention.
but this because this judgment, it even applies to commercial tenancies.
Correct.
2019.
Now we'll look into it.
Now,
We'll-
2019 also considers another judgment that is of 2017 Agarwal judgment. Look into it.
But, anytime, Lord, if for the purpose of extension, that they are proceeding with the execution, that is the only reason. I get a appeal admitted and Lord,
এই দেখো এটাকে মার্ক করে রাখো, আমার সঙ্গে কথা বলুন, ঠিক আছে? পারলে নেবো, না হলে হবে।
and Millard,
Milord, may-
Millard, under extreme urgency, Millard, this is a civil revisional application, Millard, preemption, section 8. Trial court and appellate court found against me. Prima facie, Millard, absolutely perverse order. There was a village Salisi which was treated as a notice within the meaning of section 8, read with 5 subclause 5. They're absolutely, Millard, palpably bad order.
Won't be able to take.
Millard, my only request, Millard, yesterday, Millard, once the appellate court has passed the order against me, Millard, yesterday the inspector in charge of the police station called my clients. They intimated today at 4 PM, they will take possession of the property.
Can't be helped, I cannot.
But only for the purpose of, Millard, stay and
File it, you file it. Today nothing is there. You have to first file it. See,
Millard,
I follow a very clear practice even in the principal bench.
no, Millard, I'll file,
You
Millard.
file it, after getting the filing number, you
Millard,
give it to my court officer, I will look into it.
Millard, in the filing department, once Millard grants me the leave, they won't accept it for tomorrow's listing. That is the.
It's not required, you, see, that is not required. Mr. Ghosh, you
Millard, I'll come back with the CO number.
file with the CO number, then the requisition will go.
Millard, great for me.
Milords, may I mention a matter with your lordship's leave?
Yes,
Milords, this is again an extreme urgent situation. Your lordship will recall, last week your lordship heard a surfacey matter, which was
yes,
a challenge against section 14 learned ACJM's order for possession.
yes.
Your lordship had passed some interim direction and also given me liberty to agitate maintainability, etc. Milords, what has happened yesterday, Milords, they've probably, Milords, misused your order because your order, Milords, says that the auction purchaser and the bank is restrained from changing the nature character. Milords,
I have restrained them also.
no, Milords, your lordship will kindly see that order. That matter is today in list 20. What they have done last night, Milords, they have broken the tin shed and Milords tried to forcefully enter the property when I've already taken possession.
Oh.
And Milords, in that situation, Milords, I am requesting if your lordship can take that matter today. Milords, I have given notice to the other side. Milords, this is most unfortunate, Milords, what's happening, Milords, under the, Milords, probably, Milords, on the strength of your order, they are misusing, Milords.
Very well, I will look into it.
Milords, this is item 20, Milords, I am mentioning because I understand your lordship may not have the time to take this up, Milords, but I am requesting if your lordship can spend 5 minutes. I have a 2-page note, Milords, which I can hand over, Milords.
Very well, no difficulty.
Your lordship will take this, Milords, at 11, 11:30, whatever time, Milords, suits your lordship.
Let me see how the list goes. You come around, you come around 11:30.
Please, Milords, I'll give notice to the other side again, Milords. I am deeply obliged.
Item number 1, under arbitration. Item number 1, then for a short Passover.
Every day, first matter, short Passover. Why Passover?
Not actually, the advocate on record from Shiliguri, and raining.
No,
It's
she,
raining. And my lord, I have in. My lord, there was an accident in the road from Shiliguri, my lord, everybody, my lord was that huge trap. It happened.
see, if you can come from Siliguri, the learned advocate could have also come. If I leave home at 10 o'clock and expect that I will reach the court at 10:30, it is impossible, whether it is accident or no accident. Now, this has become the order of the first matter, Monday morning, first matter. You are aware from Friday night that this will be taken up at 10:30. This is the condition. Fortunately. So you are passed over.
Item number 2, under arbitration.
Yes.
Item 2 is Passover, Lordship. Passover.
My lord, yesterday I had duly served upon the office of DSJ.
Learned DSJ appearing in this
Yeah.
matter. Learned DSJ appearing in this matter. So he will come from Siliguri.
Passover. Passover.
Item number 3, under arbitration.
Lordship, I'm praying for a short Passover. Senior Advocate Mr. Rai is on his legs before court number 4, Lordship. Item number 4 also, I'm praying for a short Passover, Lordship. 3 and 4 both.
My lord, item 4, I appear for the respondent, your lordship.
Item number
Item
4.
4.
Yes, Passover. See what can be done.
Obliged.
Item number 5. Item number 4.
Fourth to Passover, 3 আর 4 একসাথেই তো চাইলো রে বাবা।
Item number 5, under civil motion.
But this is an against an order under section 10, which was allowed.
Section 10.
Section 10. In the previous suit, Millard, ad interim injunction was obtained.
Let us not go. See, section 10 is based on a different footing. Identity of the issues.
Yes.
That decision in the first suit will non-suit you in the second suit. And it will also operate as a res judicata. These are the points. Now tell me on what ground, what is the nature of the suit?
Millard, suit for declaration and injunction. If Millard kindly takes the order one.
Suit for declaration and injunction of what?
Suit for declaration and injunction on an immovable property.
Give me a brief background.
Yes. Title, declaration of title and consequence.
Who are you?
Millard, I am one of the possessors of the land. According to my case is Millard, with title deeds and everything, Millard, I am the rightful owner in the property. And Millard, the previous suit was filed, Millard, on the ground, Millard, same relief. Declaration was sought. Now, Millard, no service was effected upon me. I was not made a party. Once the ad interim injunction was obtained, they continued with the suit. Subsequently, I filed the second suit.
No, but I didn't order 39 rule 3 compliance is required.
Millard, nothing was done, not served upon me. Once, Millard, let them demonstrate. Once I finish, let them demonstrate. Service was not done. Once the second suit was preferred, upon gaining knowledge about the second suit, they added me party in the first suit and then moved the section 10 application. That is, Millard, the narrow area where my case lies. So that this was absolutely, Millard, an order obtained behind my back and Millard by circuitous manner. If Millard kindly considers the facts.
See, the difficulty is that elsewhere, if the amendment is allowed, I have not looked into the papers, I will look into. I take your submissions to be true and correct. Amendment is allowed. The moment amendment is allowed, it relates back to the date of filing of the suit, unless the court specifies it that this amendment will take effect from the date on which the amendment application was made or the amendment order was made. The 2001 8 SCC. Now, the difficulty is that you have not challenged that order.
No, that was not challenged.
Then today you are
The order neither shows that it was directed to be delayed back from the date of filing.
automatically. That's the automatic thing. You have to automatic thing.
Millard, if Millard kindly considers the order once. Millard kindly takes page 72, my written objection to their application under section 10.
See, end of the day, looking into that will not help you because suit for declaration and injunction, 34 specifically that in respect of the sale property. Now, in the first suit goes for trial, they have to prove their case, and you will also get, since you are a party to that, you will also get an opportunity to rebut their case. Now, in that situation, what will happen if your suit is allowed to proceed? They are before the same court, I think.
They're before the same.
So if, say, your suit is allowed to proceed and his suit is adjourned, then it will to be the prejudice of the plaintiff, that is opposite party. So the best thing can be done. Both the suits can be heard out and
And lowest. But that much, my lord, if your lordship grants, my lord, then we have no difficulty.
What do you say?
That can be done, but our case that there will be multiplicity because the same pair, they are basing on the same title deeds, same parties.
See, if the suits are heard analogously, then the scope will be narrowed because you
Yes,
can use
That
the
in one
evidence.
aspect that will be narrowed.
You can use the evidence in one suit to be also the evidence in the other suit.
In the other suit.
Be practical, be practical.
If my lord modifies to that extent, my lord, no difficulty.
That can be done.
Take down. It is this application arises out of an order dated 9 September 2024, passed by the learned civil judge, bracket a junior division at Jalpaiguri.
First court.
In the cost title, no first court is there.
But now there are two.
Oh, very well. Judge Junior Division, first court at Jalpaiguri in title suit number 84 of 2023, by which the application filed under section 10 of the Code of Civil Procedure 1908, in short CPC, by the petitioner was dismissed. It is the case of the petitioner that the opposite party filed a suit for which one is your suit and which one is
Let the subsequent suit is my suit.
which one?
That
At
is
page 27, earlier suit,
213.
no, 2022. Page 24.
Page 27.
Lordship.
Filed a suit being title suit number 213 of 2022, seeking declaration, injunction and consequential relief in respect of an immovable property described in the schedule of the where is the schedule?
Page 33.
Schedule of the plaint, full stop. He said the plaint filed in the said title suit number 213 of 2022 is annexed at page 27 of this petition. The petitioner says that in respect of the same suit property, the petitioner has instituted
Page 44.
instituted a suit for declaration, injunction and consequential relief on the ground that the petitioners are the rightful owner of the said property, and the opposite party is infringing its legal character and rights. Full stop. The petitioner also says that the opposite party in his suit obtained an ex parte ad interim injunction but did not comply with the provisions of Order 39 Rule 3 of CPC. In any event, the petitioner was not a party to the suit when the same was initially instituted.
Petition number 2 and 3, one was party.
2 and 3. Two of the petitioners were not party.
কি বললো? Two of the তাহলে two কি বললো? কি সেন্টেন্সটা?
Petitioner was not a party to the suit.
Petitioner number 2 and 3
were not a party to the same suit. The said suit on the same was initially.
Only the petitioner number 1 was a party. It is also the case of the petitioners that after coming to know about the institution of the suit by the petitioners, by the petitioners, the opposite party made an application for adding the petitioners number 2 and 3 as parties to the said suit, being title suit number 213 of 2022. On being added as party defendants, the petitioner, the opposite party, got the order of injunction extended against the petitioners number 2 and 3, apart from that which was existing against petitioner number 1. In this background, the petitioner number, the petitioners filed the application under section 10.
Opposite parties. Opposite parties.
Oh, sorry. Opposite parties filed an order. Opposite party filed an that is what I was thinking. 84-year suit. Opposite party filed an application under section 10 of CPC for stay of the title suit number 84 of 2023 filed by the petitioners. This application has been rejected.
No, allowed.
Allowed.
This application was allowed by the order into being aggrieved by the said order, the petitioners have challenged this said suit. Challenged the same. ওপরে একদম ফার্স্ট প্যারাগ্রাফে চলে যাও তো।
Yeah, because I did out of an order to get 9 section of the country for father and the dinner with the passport. Journal in Chattis would number 8 by doing here, because or then of the order by the opposite party.
Opposite party
First,
was allowed.
was allowed.
ঠিক আছে, এটা ঠিক হয়ে গেল।
Being agreed by the order.
On behalf of the opposite party, it is submitted that the learned trial court has assigned reasons for allowing the application application under section 10 of CPC after considering the facts of the two cases. Two cases. Admittedly, the suit filed by the opposite party in next one. ওইখানে না না ওটা পরে করবে। The opposite party also disputes the contention of the petitioners regarding their ownership and legal character in respect of the suit property. ঠিক আছে, এবারে admittedly the suit filed by the opposite party is prior in time. It is also an admitted position that the two suits relate to the self-said immovable property. The petitioner is claiming the opposite party is claiming right title interest, and as such, opposite party is claiming declaration of its right title interest and injunction in his suit in respect of the property against which the petitioners are also seeking a declaration in their suit. The issues therefore, the case of the petitioners in their suit, therefore will be the defense of the petitioners as defendants in the suit filed by the opposite party. Bracketed 213, ওই একটাতে ওই আগে দিয়ে দাও 84 of 2023 আর এটাতে দেবে ব্র্যাকেটে 213 of 2020। ঠিক আছে, the issues therefore will be identical. Moreover, the decision in the first suit, if it goes in favor of the petitioner, if it goes in favor of the opposite party, will non-suit the petitioner, will non-suit the petitioners. At the same time, if the petitioners succeed in resisting the claim of the opposite party in the suit being 213, the contention of the petitioners in their suit will be also upheld. In the facts and circumstances as aforesaid, I do not find any infirmity in the order impugned. However, in order to prevent complication and multiplicity of judicial proceedings, I direct that the two suits being title suit number 213 of 2022 and title suit number 84 of 2023 be heard analogously, since the same are before the since the said two suits are before the same court. Nothing further remains in the application to be decided. Same is accordingly disposed of. No. There is no interim order, I suppose.
Yes, there is a
There
stay.
was a stay.
Huh?
There was a stay of the.
The interim order directing stay of all proceedings in 213
2 months.
of 2024 stands vacated. Full stop. 213 of
No, 84 million. I'm sorry, 84.
Oh.
Stay was
In
granted in
84, subsequent. suit was
subsequent suit, subsequent suit.
Ah,
was
oh, it's
84 of 2020.
84 stands vacated. ওটাকে আগে করে দিই, nothing further remains to be. These are things which I have to point out before the.
Item number 6. The civil motions.
Yes, that matrimonial suit.
Yes,
My lord, domestic violence.
the correct remedy, my lord, is filing a criminal revision instead of a civil petition. The confusion arose because of a judgment and order passed by a full bench of the Madras High Court. Wherein it was held that section 12 being a remedy civil in nature, the appropriate forum, it was held in Arun Daniel versus Suganya. That section 12 proceeding being the civil in nature, the appropriate forum was Article 227 civil revision. Later on, this has been clarified by the Delhi High Court, saying that yes, in case of only simplicity section 12, it will be civil division. But wherein the judgment has traveled through the district and session judge, and thereafter it is coming, then criminal revision is the appropriate.
The statute is very clear.
Yes, your lordship. Even lordship kindly comes to section rule 6(5) of the rules.
দেখো তো
lordship.
এখানে আছে
That I am giving. Lordship kindly see the rule 6(5). The application under section 12 shall be dealt with and the order enforced in the same manner laid down under section 125 of the Code of
ওইটা দাও
Penal
পরে
Procedure.
খুঁজে বার করে দাও। না
Yes. Even my lord, it has been stated that it has to be dealt as per the manner provided under section 125 of Code of Criminal Procedure.
the subject matter of challenge in this civil revisional the subject matter of challenge in this civil revisional application is an order passed under section 29.
29.
But that is not the final order. That is the order of stay.
yes.
Yes, final order তো হবেই না তাহলে।
Is an interim order passed in an application, passed in an appeal under section 29 of the Protection of Women from Domestic Violence Act 2015. The appeal arises out of an application of order, arises out of an order passed in an application filed by the opposite party wife under section 12 of হচ্ছে ওটাকে ডিভি অ্যাক্ট করে দেবে, ঠিক আছে? 12 full stop. The opposite party number, the opposite party number one, the opposite party at the threshold has raised a maintainability point. No, at the threshold has objected to the maintainability of this civil divisional application. According to the opposite party, the provision of section 28 of the DV Act clearly states that clearly stipulates that save as otherwise provided in the said act, all proceedings under section 12, 18, 19, 20, 21, 20, 21, 22 and 23 are offenses under section 31 and offenses. And 23 and offenses under section 31 shall be governed by the provisions of the Code of Criminal Procedure 1973. Full stop. Furthermore, according to the opposite party, Rule 6 of the Protection of Women from Domestic Violence Rules 2006, in short, the said rules, also say Rule 6(5) also says that applications under section 12 shall be dealt with and orders enforced in the same dealt with and the orders enforced in the same manner as laid down under section 125 of ওখানে Code of Criminal Procedure CRPC করে দাও of CRPC post. The application therefore is not maintainable. this application, comma, therefore, comma, is not maintainable. According to the opposite party. On behalf of the petitioner, it is fairly submitted by citing two judgments. Passed by the Madurai bench of the Madras High Court on 15th April 2024 in CRP, all capitals, C full stop R full stop P, bracket A, MD, all cap, number in capital, number dot 833 of 2024, and CMP, bracket A, MD, numbers 4647 and 4648 of 2020. As also the Delhi High Court judgment as also a judgment delivered on 19 January 2024 by the Delhi High Court in CRL REV CRL dot REV all caps dot B dot 2024 of 2021 bracket হচ্ছে Swapna Paul SAPNA Swapna Paul PAUL versus Rohin Paul, that in the event
There are 22.
yes, কি বলবো event the challenge is to the order under section 12 of the DV Act, then a civil revisional application under Article 227 of the Constitution is maintainable. But when the order passed by the Sessions Court under section 29 of the DV Act, the challenge has to be under section 482 of CRPC.
397.
Now, ওটা হচ্ছে 482 of CRPC corresponding to 389. না, corresponding to which section of BNSS?
482, 520.
BNS আছে ওই দেখতে corresponding to 442 and section 528 of the Bharatiya Nagarik Surakha Samhita 2023. Right? In short, BNSS. After hearing the parties and considering the materials on record, I find that the objection raised by the opposite party is a matter of substance. Moreover, the petitioner has also, by citing judgments, fairly considered that the order passed by the sessions judge or by the district and sessions judge under section 29 of the DV Act is assailable only by filing a criminal divisional application under sections হচ্ছে যেটা দেওয়া আছে ওই না 401টা দিলাম না এক্ষুনি দিলাম 442 and 528 of the BNSS system. In the aforesaid facts and circumstances, this application is dismissed as withdrawn on the prayer of the petition on the prayer of the petitioner. Yes, you are free.
With liberty to appropriate.
No.
How we are withdrawing it?
Shall I dispose it of or?
No, we are withdrawing it with liberty of my lordship.
Because it may create trouble for you.
Yes.
Because why did you withdraw before the client? So that's the reason I'm asking. shall I
No, no, I will withdraw it. I will get the liberty to
uh,
file appropriate.
Dismiss as withdrawn on behalf of the petitioner.
by granting the petitioner liberty to challenge the said order in accordance with law before the appropriate forum. Huh?
You don't say that. The agreement of church in this case has application is an interim order passed in an application.
In an appeal court, ওটা application না, in an appeal
Also 29.
preferred under section 29.
Right. 25 that. Order passed in an application by the opposite party, and it is 12 million.
হ্যাঁ হ্যাঁ ঠিক আছে, ওই প্রথমটা পড়ো, ওখানে ক্লিয়ার করে দিচ্ছি।
Starting order of challenge in this case is an order passed under section 29. Section 29 of the is an interim order passed
Under section
in an appeal. Preferred under section 29 of the
by the petitioner, bracket a husband. হ্যাঁ না, by challenging the order, তাই তো, তাই আছে তো, চ্যালেঞ্জ
Challenging the order passed in an application filed by the opposite party wife under section 12 of the petition.
এইগুলো জাজমেন্ট
My class.
হ্যাঁ বলছি কোনটা
Item number 7.
Milords, may I, Milords, well, your Lordship, before this to mention, Milords, item 20, I had mentioned earlier, your Lordship indicated that I should remind at 11:30.
Yes. Where is
Milords,
the,
item 20.
where is the other side?
Milords, I believe Mr. Singhal and Mr. Deboshri Dhar were there, Milords. I had informed them also. Milords, I am assuming they're in court only, Milords.
Very well.
Your Lordship may kindly see the order, Milords. I think it will be clear if your Lordship will.
It will be the first matter tomorrow.
Your Lordship, there's some urgency. Otherwise, I wouldn't have troubled your Lordship because what's
You have
happening,
been-
Milords?
See, the difficulty is that if I go into the merits of the matter, you will be in further trouble. You are asking citing urgency.
Milords, Mr. Singhal, I can see is there, Milords. If your Lordship may just take it for 5 minutes, I will not trouble beyond that if your Lordship is not convinced.
Very well. Mrs. Miyanka.
Item 20, Milords. This is speed fast construction.
So this is a big matter.
Yes.
Assisting him, my lord, because he was not there in court. He is not yet reached, my lord.
Very well. Tomorrow first matter.
Please, Milords.
Ask Mr. Choudhury tomorrow first matter.
Grateful, Milords.
Item number 7 under civil motion.
Please, Lordship, am I audible for item 7, Lordship?
Yes.
Lordship, I'm there for the
Number
applicant.
7, Mr. Seth is appearing.
Yes, I'm there. Lordship, I'm Mr. Sheth. I'm grateful.
Milords, I appear for the opposite party, Milords, in item 7.
Lordship, this matter was listed on last Thursday. I apologize, I could not attend. I had some personal difficulty. Lordship, but I understand my colleague had briefed my Lordship on the matter. Lordship, just to brief my Lords again, Lordship, this is a matter arising out of an order where an Order 7 Rule 10 application has been refused.
Yes.
And against that, we've come to this Honorable Court.
Yes.
Just to give a short background in this matter, Lordship, the contract in question was a supply of certain goods and machinery to the other side. There's a purchase order in place. The purchase order does not have any reference to any jurisdiction clause. Thereafter, there is supply of this material in that supply, with the supply, there is an invoice. In the invoice, there is a jurisdiction clause. There is non-payment of this material. So I initiated recovery proceedings before the Ahmedabad Civil Court. In subsequent to the point of time, there is a countersuit that the other side has filed against us in the Siliguri court. Now, with this
The,
background,
the
yes,
purchase order or the invoices, tax invoices do not contain any arbitration clause.
there is no arbitration clause.
Very good.
Now, this plaint that is filed before the Siliguri court effectively says three things. One is that, sir, there is some delay in supply. That is one. Second is that the goods that are supplied, there is some deficiency in that, quality issues. And third is, sir, that please see the invoices that you have raised. The invoices that you have raised have a term of CST, Central Sales Tax, and we feel that the goods have come locally within the state itself, not from Gujarat to all the way to Calcutta. So there is no question of central sales. So the claim is very specific to the invoice. Lordship only have the copy of the prayers. The plaint starts at page 14.
See, Mr. Seth,
Yes, sir.
we are not at the stage going into the merits of the matter.
Sir, we are not. I'm just on that since the invoice is taken into consideration.
What is the ground for which? Because order 7, rule 11, A to D, you have the grounds. You have to come within the four corners of those grounds.
Sir, I'm 710. I'm not 711, sir. I'm 710.
710. 710, return of the plaint.
Return of the plaint. I'm saying no jurisdiction because the last understanding between the parties was that the courts at Ahmedabad will have jurisdiction. And there was a suit that was filed there as well. There's a written statement filed there in the suit in Ahmedabad. There is no objection raised on jurisdiction there. And thereafter, there is a suit filed in the Siliguri. But I am satisfying the court on what is the last understanding between the parties. And the last understanding was that courts at Ahmedabad will have jurisdiction.
I told you I dealt with this matter very recently.
Yes, sir.
Judgment very
Beyond minds, my lords.
beyond minds. You will find
Please,
that
my lords.
I have discussed the entire law over there.
Please, my lords.
Sir,
My lords, in fact, I am relying on that judgment, my lords.
Sir, I'm grateful to Lordship and my learned friend. We have not had a chance to look at that copy.
I
but-
told your junior did not look into or inform you. What can I do? I told it on that day itself that this issue in respect of the jurisdiction, see, previously the judgment starting from ABC Laminate, subsequently Moga Transport and up to Man Roland, where that the jurisdiction can be of one court can be excluded by understanding or agreement between the parties by conferring jurisdiction only exclusively to one court. Now, this view got changed in Man Roland. Justice Rumapal delivered this judgment. The Supreme Court says that if the parties by an agreement has chosen a particular forum, it has to be construed that the other forums are excluded. So the requirement of only exclusive words are not necessary.
So
this point was further clarified in 2013 in Swastik Gas.
yes, sir. Sir, we are relying on Lordship.
So,
This
clearly, it was here. Now, the situation is that even if there are Delhi judgments, there is also a Karnataka, or I have considered those in via minds,
yes, sir.
which says that if the tax invoice contains a jurisdiction clause and the tax invoice has been accepted by you and acted upon, that will amount to accepting the jurisdiction of a particular court.
Sir, this is entirely in my favor. This is entirely in my favor. Lordship, whatever my lords have said is what is in my favor. This is exactly what I'm asking for.
No, but you have to show that.
I will show that. I will immediately show that. Lordship may see the copy of the invoice, Lordship, at page 66. This is exactly what I'm arguing. Lordship has in fact said what I am going to argue. I am grateful to the court, Lordship.
Yes, where are the invoices?
Lordship, my page 66. This is the invoice. This is the last understanding between the parties acted upon. Part payments made based on these invoices. Now saying pay it back because you have defaulted. I find difficulty in your goods that you have supplied. This is exactly the case. Lordship, may page 66. Lordship may see towards the bottom. And Lordship will see towards the bottom, item 4, subject to Ahmedabad jurisdiction.
Yes.
And Lordship will see the reference to the PO number. The PO number, Lordship will see 19 on the top right.
This payment, the tax invoice has been, the payment has been made in respect of this tax.
Yes, Lordship. Yes, Lordship, acted upon. They are saying that there is a grievance. We have a difficulty. You have asked for CST. Lordship will see. Lordship will now see that there is central sales tax referred to 2%.
Yes.
His entire grievance is you could have never claimed central sales tax. That is his prayer. Lordship will see the prayers are at page 22.
Yes.
Yes, and Lordship will see page 22 is his prayer. If my lords may please to have page 22. And Lordship may see C for Calcutta. Lordship will, I'm sorry.
Yes.
Please, Lordship. Lordship will see the averments in this regard. Para 11. I showed my lords bill number 44. His whole dispute is in relation to the bill. Lordship will have para 11 at page 18. Lordship, the relevant are 3 paragraphs. Lordship, para 11, para 12, and para 13. Para 13 shows payment under the bill, which is saying has to come back to me.
The tax invoice you showed is in page 86.
66, sir. 66, sir. 66. I showed my lord's bill number 44. They all have the same language. I'm showing lordship one bill, page 66. On the top right, lordship will see bill com number 34. On the top right.
No, I want to only black it out.
Yes, sir. I am grateful, sir.
Yes.
Lordship, may please to come back to paragraph 11, 12, and 13. They're relevant. Those 3 paragraphs are relevant. It's their own say.
Yes.
In para 13, they say that, so in para 11, I'll just read the last 3 lines.
So now we come to the order impugned.
Yes, please, sir. Impugned order at 148, sir. Sir, 3 points impugned order says. One is, sir, you can't file it at this stage because trial has begun. Sir, order 7, rule 10, Supreme Court says powers can be exercised at any stage.
What is this position of your Ahmedabad suit?
Sir, what it was dismissed for default because the promoter had passed away. We filed a restoration. Restoration is under.
Milords, I'm sorry, Milords, to interrupt. There is no pleading on Ahmedabad suit at all. So my friend Milords should inform your lordship today that there is no pleading at all.
My friend has pleaded the Ahmedabad suit in the plaint, not once, repeatedly. In fact, his claim in the cause of action is that I have cause of action to file this because he has filed Ahmedabad.
Your suit has been restored.
No, sir. Application for restoration is pending, sir.
Oh, there is no issue as on date.
Sir, I'm not on that. Sir, I'm not on. Sir, for me to argue saying that because Ahmedabad was moved first, 710 return the plane to Ahmedabad. No, sir, that is not my argument. My argument is that parties have agreed to Ahmedabad jurisdiction. And Lordship itself said that once I say Ahmedabad, I don't need to say exclusive. I don't need to say only. If Ahmedabad is written, Ahmedabad will get jurisdiction. What is the last? And Lordship in the last position that my lords referred to the Wyoming mines case, that whatever is stated in the invoice being the last understanding, invoice acted upon. Yes, same situation. Last understanding, invoice acted upon, grievance under the invoice, which says Ahmedabad jurisdiction. Hence, give me 710 and send it back to Ahmedabad. That is my argument, sir. It's his own case. I am not saying because Ahmedabad's earlier suit pending, so send it to Ahmedabad. No, sir, that is not what I'm saying.
Very well. What is your...
Yes, Milords, what my learned friend Milords is not informed your lordship is the timelines, which is extremely crucial, Milords. The suit was filed in 2012. I filed a plaint in the Siliguri court. Milords, my learned friend's client files a written statement. That written statement, Milords, is on record. In the written statement, they accept the jurisdiction of Siliguri court. And Milords, may kindly see that written statement for a moment. This was, Milords, filed in 2014. Milords will see page 32, para 18.
No, where is the written statement?
Milords, in the file, Milords, at page 32. Milords, the relevant portion is at para 18. It starts at page 25, Milords. The written statement starts, which he filed in 2014, Milords.
Page 20?
25, Milords, 25. Milords will kindly see para 18, Milords, at page 32. This is their response to my specific pleading on why Siliguri has jurisdiction.
Para?
Para 18, my lords, page 32. My lords, last 3 sentences, 4 sentences, my lords, is where they respond by saying that there is no cause of action which has arisen. They don't talk about invoice. They don't talk about exclusive jurisdiction. No objection taken, my lords. So they participate, my lords, in the suit.
The participation in a suit does not. Suppose there are judgments. Suppose I submit to the jurisdiction of the court for the purpose of challenging the jurisdiction.
No, please, my lords.
Will it amount to submitting to the jurisdiction?
My lords, I bow down, my lords. That's a case where, of course, my lords, they will have grounds to raise, my lords. There's much more to that. Then, my lords, what happens is, in the meantime, they file a suit in Ahmedabad. That plaint, my lords, my colleague is carrying. She will hand over the plaint. They have not filed the plaint. In the plaint, my lords, kindly see what is their case insofar as jurisdiction is concerned. There also, my lords,
But
they don't.
admittedly, the Ahmedabad suit is a prior suit.
It's a prior suit,
Exactly,
my lords, but
Lordship.
today,
It's a prior
one second, Mr. Seth. But, my lords, kindly see, my lords.
I'm sorry. The only reason I interrupted because you said that it was subsequent in point of time. That's
No,
the
in the
only-
meantime, I said. I'm sorry.
No, so in the
My lords,
meantime is subsequent. I'm sorry.
my lords, may kindly see para 8. What is their case, my lords, when they filed the Ahmedabad suit on jurisdiction? They don't talk about invoice. They don't talk about exclusive jurisdiction. My lords, this is page 7, para 8. At the bottom, my lords.
Yes.
So, my lords, written statement filed. They take all objections. They don't argue on exclusive jurisdiction. They file an Ahmedabad suit prior in time. They take no plea with respect to exclusive jurisdiction. The fact today is, my lords, the Ahmedabad suit has been dismissed for non-prosecution, while they have filed an application for restoration that has not been allowed. In the meantime, my lords, the Siliguri suit has progressed substantially. Issues have been framed, and the matter today, my lords, after 13 years, the matter today is at an evidence stage. At this stage, my lords, they come back with an application on 7/10, praying that the plaint may be returned on the ground that the invoice has a clause. Now, my lords, coming to the judgment that your lordship has given, one key factor, my lords, in your judgment that your lordship had laid down is that there has to be a meeting of minds. The parties should agree to the same clause in the same meaning. Now, my lords, in the facts of this peculiar case, when, my lords, in the last 13 years, neither party brought about this.
See, honestly speaking, you may be saved only because of their incorrect pleading. Because I think Mr. Seth was not there at the time of drafting of the plan. Otherwise, he would have taken this point. Now, cause of action, they have pleaded, see, Sale of Goods Act, cause of action. See, a civil suit if you read the conjoint provisions of section 9, 16 to 20,
Please, my lords.
find that it has to be filed in the court having pecuniary jurisdiction, and so far as territorial jurisdiction, from 16 to 20 lays down
Different criterias.
20 part cause of action.
Please,
So
my lord.
they have pleaded part cause of action. They have not said, which I agree with you in the plate, that their cause of action is based on the general conditions, because normally a suit has to be filed in the court where the defendant resides or voluntarily carries on business.
Please, my
So,
lord.
normal forum in case of suing was Siliguri. Now, this can be excluded by an agreement between the parties. This
Please, my
can
lord.
this can be excluded by saying that Ahmedabad court, because they have the registered office, part cause of action has arisen for sale and delivery of the goods therefrom. So they can maintain a suit. It's not that they cannot maintain a suit at Ahmedabad. Now today, this point of jurisdiction, exclusive jurisdiction, you say that they have not taken in the written statement, and they have also not pleaded this exclusive jurisdiction in the plaint filed in the Ahmedabad suit. So after 13 years belated stage, this should not be allowed.
Yes, my lord. That's precisely my submission in two more points, my lords. One, my suit, my lords, if your lordship were to see my plaint, my case in the plaint is on the basis of a purchase order, which preceded the invoice.
No. That part I am absolutely sure. The tax invoice, once it is, it contains a exclusive jurisdiction or a jurisdiction regarding a particular conferring jurisdiction or particular way, it has to go. But they have not. But they have not taken this point.
Milords, I bow down. Milords, on this.
That is where you may be safe. I'm not saying you may be safe.
Milords, there are two things to consider, Milords. Of course, Milords, I am not joining issues on the plaint if your lordship has a different view on that. What I am saying today, Milords, even in a case where invoice has a jurisdiction clause, what your lordships will see and has been seeing in numerous judgments is that there has to be a meeting of minds. If, Milords, the other party himself has not given effect.
Your strong point is elsewhere. Your strong point is that the objection to the jurisdiction has to be taken up at the first instance.
Please, Milords.
Not taken up, it will be deemed to have been waived.
Yes, Milords, if I may just cite one judgment, Milords, of Supreme Court on this, Milords, for your lordship's consideration. I'm sure your lordship is aware, but for my satisfaction, Milords, Harshad Chimmanlal Modi versus DLF.
What does it say?
Milords, on exactly the point that your lordship mentioned at the first instance, and in any case before filing of written statement and framing of issues.
Yes.
Today, Milords, we are, Milords, 13 years ahead of the filing of the suit, where, Milords, my friend's client has come up with a 710 application. That, Milords, is completely prohibited under section 21, read with numerous judgments. Your lordship will see, Milords, para 30 of this judgment is very clear.
My friend may give us the citation. We'll simultaneously, or he can send it on WhatsApp or put it on this group.
That's the reason, Milords.
My friend may share the citation. We may simultaneously have a look.
This is 2005 7 SCC 791.
2005. Paragraph?
It's 3030. Mr. Seth, you've gotten the citation. I'm sorry.
It's 2005 7 SCC 791.
Yes.
We are pulling it out. If you can share it on the group here, PDF. Manu,
Yes.
Milords, there's of course, Milords, a series of judgments which follow this. There's a recent judgment of 2025 also of the Supreme Court, very clear on this point. The fact that you have not taken it at the earliest opportunity, that objection is gone. And Milords, this is a unique case, Milords, where 13 years, Milords, I have proceeded with the suit. They have participated. And today, Milords, at this stage, when the matter is at an evidence stage, they come with a 710 application, Milords. And Milords, last point, Milords, there is also, Milords, a concept of what is the prejudice that is caused to either of the parties if the suit were to continue in Siliguri jurisdiction. That, Milords, neither my friend has pleaded. And Milords, in the facts of the case, my respectful submission is there is a lot more inconvenience if the suit is transferred. Then, Milords, it's allowed to, Milords, go through in the Siliguri court itself. Milords, I'm grateful, Milords.
sir, I may just quickly respond to.
For the forum convenience, you have a judgment of 2022.
Please, Milords.
Sir, if my lords permit, may I address?
Yes, yes.
Sir, just my friend's paragraph of cause of action in the plaint and my response. If my lords may please to come to para 18 because the whole para is not read. I fail to understand how it is that on reading that entire paragraph 18, at what point of time do I concede to the jurisdiction based on that language? I'm not able to understand. If my lords may please have page 32, para 18, where I'm completely denying if I'm saying it's an abuse of process, that is my language. So I'm not sure how it is that my friend is saying that I have tendered.
Mr. Seth, your client has not challenged the jurisdiction of the court.
That's the point, Milords.
Sir, I have said that in my his case, sir, right now the argument was that, sir, WS where you have said, how can you come up with 710 after 10 years? That is the argument.
No, that is not the issue. Issue is that you have filed the written statement. In the written statement, where have you taken the point of jurisdiction? That
Sir,
Supreme Court does.
Sir, if my lords may please to, if I can trouble my lords, I don't.
Yes, no difficulty. You trouble me.
Lordship may please have para 18. Lordship will read it together. If at any point of time in opposition to his language saying Siliguri court has jurisdiction, where do I say yes, Siliguri has jurisdiction, I tender, right? You may just read that.
Sir, the difficulty is that you are filing a written statement.
Yes, sir.
You know that denial has to be clear and specific.
Sir,
evasive denial will not help you out. So your first point is that this court does not have the jurisdiction. Where is that?
Sir,
you deny his allegations. Where is your assertion?
Sir,
denial does not denude the court of the jurisdiction. It is your assertion. You have to say, look here, this court does not have the jurisdiction.
Sir, I'll read 18 and based on what I understood that I have not said Siliguri has jurisdiction. I filed a 710 for return. My friend says it's done after 10 years. To that, I'm saying that it can be done at any stage. And Supreme Court says so.
Mr. Seth, sorry, I can give you one more opportunity because today I will be rising. The single bench is till 12 o'clock.
Please, sir.
I can give you tomorrow.
Please, sir.
But I am with you absolutely for the purpose of that invoice jurisdiction.
Please, sir.
But the way you have framed your suit, that has chopped your leg. Now, if there is a birth defect in the plane, you know it cannot be cured even if you go up to the highest level.
Sir, very well, sir. I'm grateful, but Lordship may consider reading the plaint. At no point I tender to the jurisdiction. I've put in a 710. 710 can be considered at any stage. Supreme Court says so. I'll assist my lords tomorrow, Lordship. I'm grateful.
Very well.
Please, sir.
Just a minute. একটা order record করুন। The parties have made substantial argument in favor and against the relief claimed in this application, in this revisional application, which arises out of an order rejecting an application under Order 7, Rule 10 of the Code of Civil Procedure 1908. In short, CRPC. The arguments, however, could not be concluded due to paucity of time. Let this matter appear tomorrow.
Please, sir. I am so grateful, sir.
Obliged, my lords.
এই ফাইলটা একবার অর্ডারের সঙ্গে পাঠাবে জাজমেন্ট গুলো দিয়ে আমি একবার একটু দেখবো।
The voting will under their urgency, I mentioned this, because it has been filed. Because if you are kindly takes it up tomorrow as the first item.
Tomorrow already first item, Bharti is booked.
Second time.
Third item, second item will be this one.
Third item, great. Excellent.
ওই ওপরের দিকে দিয়ে দিও, ঠিক আছে, দেখে নাও।
That is taking up only for 1.5 months. That's why you
What can be done? What can be done?
Great.
See, I may reduce it tomorrow because if the revision bench, I find no one is eager in doing the matter, I don't mind sitting up to 150. I would have by this time polished all your motions. If I could have sat up to 150,
As your lordship.
I would have polished all your motions. Very good.
My lord, this is item number 49. It is being listed on a regular basis, whereas not been called because of it's on a later listing. My lord, I would like to seek an accommodation that the matter be listed on an earlier listing on
Where is your other side? You come and mention it tomorrow by giving notice to the other side. I will try to. What is the urgency?
My lord, the matter has been amicably settled, whereas it has not been fixed for the final hearing, my lord. My lord, the matter has been amicably.
There is no requirement of final hearing.
My lord, I've been instructed by senior advocate Mr. Bilwadal Bhattacharjee to fix the matter on Wednesday first half, your honor. Earlier listing, your honor. My lord.
No, for what purpose? Settlement has arrived at.
Yes, my lord.
Who is your other side?
My lord, I don't know. I'll notify my lord.
Notify and mention it tomorrow. I will try to place it.
Careful, my lord.
You give them notice and mention it tomorrow.
Careful, my lord.
My lord,
Yes.
my lord, may I have lordship's kind leave to mention a matter on from virtual mode, my lord. My lord, it's the first appeal. My lord, the appeal is directed against my lord money decree on account of mean profits. There was a conditional stay. Now that pursuant to the that conditional stay order, my lord, the appellant has deposited 39 crores odd. Now
Yes.
I have filed an application, my lord, for releasing a part of the amount deposited by the appellant, my lord, against my furnishing bank guarantee. Now that application was taken up for hearing on 28th April. My lord, a direction was given for filing affidavit, my lord, by 15th May. No affidavit in opposition has been filed. Now, my lord, I was beseeching your lordship, my lord, your lordship kindly direct the application to be listed for hearing. My lord, in the meantime, my lord, what happened? The paper book has not been filed. There was a direction for filing paper book. Now the records, my lord, were incomplete.
Mr. Menon,
Lordship.
who is on the other side? Have you?
My lord, Mr. Supriya Chattopadhyay, my lord, I just spoke to him. I have given notice to him. My lord, I have given my junior is there. My lord, Miss Isha, my lord, I have given a notice. I spoke to him just now. He is busy in court number 14, I was told. So kindly direct the application, my lord, to be listed for, my lord, because I don't know whether they will file an affidavit. My lord, he said that he will be seeking extension of time to file affidavit in opposition, but he's not there. I mean, 5-10 minutes. I mean, not earlier. I just had a talk with him over telephone.
এইটাকে না ওই অ্যাপ্লিকেশন হেডিং করে দিয়ে দিও
লর্ডশিপ
কাল বা পরশু দিয়ে দাও ডে আফটার টুমরো অ্যাপ্লিকেশন হেডিং
মাই লর্ড আই এম ডিপলি অফেন্সড
Item number 1. After the ready bail in connection with.
For the my lord, applicant is a bail in connection with appeal.
for the statement.
Fact is, my lord, there's a section of my lord 498, 302, 3 and 4 Dowry Prohibition Act. Now, fact is, my lord,
Application for bail or suspension of sentence?
suspension of sentence and my lord, I'm bail, my lord. Straight in one. Straight in. Now, my lord, here fact is, there was a my lord cylinder blast in a my lord kitchen. Now, wife was my lord there, he burned. Now, my lord, the husband went to recovery, the wife, he also burned. Both were taken to the my lord hospital. And initially, my lord, the wife died. And after 3 days, husband also died. Now, my lord, there was a my lord declaration made by the my lord wife. There was no declaration taken from my lord the husband. Now, my lord, based on the my lord the dying declaration, the conviction has been passed for my lord life. Now, my lord,
Against whom?
against my lord the father-in-law and brother-in-law, because and in the FIR there is also principal accusation made to the husband by the father of the wife, that is my lord the father-in-law of the my lord. Now, my lord, both has died. Now they have made the story that there was a throwing of kerosene and the husband has my lord like lit my lord a, and thereafter my lord the wife has died. Now, thing is this, my lord, thereafter, my lord, there was a my lord straw, my lord, lying in the my lord uthon, my lord, that is the ground of the deceased and my lord ground of my clients. There was a my lord fire took place in an area, and my lord, the fire brigade was called, and fire brigade ultimately, my lord, restored the situation. Now, I will, my lord, before going into the record, there are volume of records, my lord. I will show few documents for consideration of the bail, my lord. Kindly see, my lord, the seizure list first, my lord. Well, this is all from the record. Just I have, for convenience, I have made the my lord photocopies of the relevant documents, my lord. This is the seizure list 4 and 5 seized by my lord the police. There are a lot of my lord articles are there. 5 is 1 burned gas cylinder, 5 kg capacity. There are 6 is 1 gas oven, burned condition. This was the seizure. Now, if your lordship kindly come, my lord, bed ticket.
Huh?
Bed ticket, bed head ticket, my lord, at the time of admission, the last page of this document, my lord.
Yeah.
Kindly see left hand side, my lord. Accidental burn. At top.
No, that was an initial.
Yes, initial. I'm coming, my lord.
There is a dying declaration there.
I'm coming to the dying declaration as well, my lord. At what last page, your lordship got it, my lord? In first, my lord, there was a seizure made by the police, the gas cylinder and gas oven. And the last page, there was a, my lord, bed head ticket mentioning the accidental burn.
Show us the PM report.
Yes, I am showing, my lord. My lord, kindly give me, my lord, some, my lord, document to place. I am showing. There, document there.
Have you annexed the PM report?
Yes, yes. Now, my lord, kindly see the another document. The statement of, my lord, the doctor treated her. All are from the record, just, my lord, for convenience, my lord, I have, my lord, made the photocopies. But may I read, my lord?
Yes, medical officer, yes, Dr. PK.
Yes, speaker. Now, my lord, may I read this document? Very short. I'm medical officer now attached with such and such hospital. On such and such, I was posted at the time, place in the capacity. On the same day, I held PM over the dead body of Rejak Mia, such and such, under a such and such. On examination, I found reflected ulcer following burn injuries over left side of the whole face, neck, upper part of the chest, left side of the abdomen, front aspect of the left thigh, a small area of right lower such and such. Thereafter, my lord, kindly see, my lord, next. I have opined that date was due to the effect of the burn injuries as noted above, antemortem and accidental in nature. Now, cross-examination by the prosecution kindly come. I have opined accidental on the basis of the inquest report and previous medical reports of the deceased. No medical report has been produced today. Inquest report has not been produced before me. Not a fact that I have stated falsely that the death was due to the effect of the burn injuries as noted above, antemortem and accidental in nature. This was the statement of the doctor. Now, next statement I have also, my lord, want to show to before your lordships. Yes. Bappa Mia, my lord, he was the neighborer. I know the accused, such and such. Rejak Mia is the elder son of such and such. Name of the Rejak Mia, such and such. Such and such, no more. The Kurshit are no more. They have died due to the fire in their house. Both are died at such and such hospital. The accident happened on 22nd December 2013 at about such and such. I was at my own house. The house of Kabiruddin is about 20 meters away from my house. I came out from the house. After hearing hue and cry, I found that the fire caught in the house of the Kabiruddin Mia. There is a pond which is adjacent 10 meters away from the house of the Kabiruddin. I found that the Manik and Kabiruddin and the wife of Kabiruddin are catching fish in the said pond. Well, that is, my lord, my clients, those are before your lordships were not present. They were catching, my lord, fish in the pond nearby. Pond, I called them. They immediately came to their house. About 40 to 50 persons were there and tried to douse the fire. I also tried to douse the fire. I found Rejak and Kabiruddin are burning. I have a Maruti van. I took them at such and such hospital by the said Maruti van. I have accompanied by Samsir Mia and Ratan Bormon. Both were admitted in the hospital. The number of vehicle is such and such. Police examined me in the case and I have stated that same I have today before this court, police custody such and such. I previously got summons from this case. So this was the statement.
Who is Ratan Bormon?
My lord, they were, my lord, the neighbor.
Somin Mia?
They are neighbor, my lord. Now kindly come the postmortem report in the same document and the last page.
Yeah.
Effect of burn injuries and such, accidental in nature. At the last page, your lordship got it, my lord? Yes. Now. Inquest, maybe in the, my lord, record. Now. This is the vital, my lord, document here, my lord, medical officer who, my lord, taken the, my lord, dying declaration of the, my lord, wife. That is the most vital, my lord. May I read this, my lord?
So, were there any previous complaint regarding the matrimonial
nothing.
discord?
No, there was no previous complaint. There was a, my lord, cylinder blast.
No,
Husband,
no.
my lord, went to, my lord, recover her.
The father of the wife in the complaint had made allegations that there were torture.
Dowry and etc. But there is no previous complaint. Father of the, my lord, wife also, my lord, made the principal accused to the husband who has also died. My lord, may I read, my lord, this? Yes. If your lordship kindly see, my lord, the statement of the doctor, based on this, my lord, document, my lord, the sentence has been passed, my lord. This is the strong reliance has been placed by the prosecution. My lord, may I read, my lord? I am the medical officer now posted such and such hospital. I was posted at the same place with same capacity. In addition to that, I was acting as a such and such. On the same date, I held PM over the dead body of such and such Muslim woman in connection with Kotwali PS. Yes, now in the last paragraph, last page of this, my lord, document, if you lordship kindly see.
I did not ascertain whether any relative.
Yes, and he also, this doctor also, kindly see, I did not go through the bed head ticket of the patient. I have shown to your lordship the bed head ticket. In the bed head ticket, it is specifically mentioned that the injury was done, my lord, on the based on the accident. That was the initial, my lord, statement made by the, must have been made by the, my lord, deceased. And both have died, my lord. This is not the case. Yeah. That wife has only died and husband is alive. Husband also died to recover his wife. And here who are the, my lord, now behind the bar, the father-in-law and, my lord, the brother-in-law. They have no role to, my lord, play with these issues, my lord.
Have you got the dying declaration with you?
Yes, dying declaration, no, my lord. Dying declaration, my lord, here. This is the, my lord, statement made by the, my lord, doctor.
Evidence.
Evidence.
Declaration, that document.
Bank declares, my lord, on the record, my lord. I have not yet, my lord. It's not there. They have admitted the existence of bank declaration in the cross-examination, my lord. In the cross, if something is admitted, there is no escape.
One certificate is required that the patient was in condition to make.
My lord,
That is the ingredient.
It is the evidence.
Because of the fact 90%.
90%, get to the. But she was conscious. In the
90%, considering the degree of the burn injury, this certificate is inhibiting
My lord.
that he was in a condition. Court has taken note of this fact. She got admitted on 22nd and died on 27th. That means 5 days in hospital.
My lord.
But he was in a condition to speak
That is it. That is the
or
evidence.
to make. He was.
That is.
And
my lord, one my lord, very striking fact. Her husband was also alive, but his statement has not been taken by the doctors nor by the police. He was 3 days was my lord alive. After 8 days, husband died. After 5 days, wife died. Both were admitted in the same hospital. May I, my lord? May I?
So he is making a.
My lord.
You're complete.
My lord. I will, my lord, reply if necessary, my lord.
Yes.
My lord.
Mr. Vishwas.
Yes, my lord. First of all, my lord, this is the third application under section 389(1). This is the third application. Earlier 2 occasions, this prayer was turned down, my lord. Mainly on the basis of the, I've gone through the order sheets on the basis of the dying declaration, my lord. The principle is, my lord, is whenever, principle is that no one will meet his maker with a lie in his lips. Same principle applies here. So, dying declaration is not at all disputed, my lord. There, my lord, subsequently, it appears from the evidence of the doctor who recorded the dying declaration that on that time, the patient was conscious during recording for dying declaration. Diagnosis was at that time was 90% burn injury. This is the second line, my lord. 90% burn injury was there, but the doctor has opined that she was in a conscious state. She made the statement. Number one, lordship, she made the statement before a doctor recording the dying declaration, my lord. In the cross-examination part, kindly come at page 27, my lord. The next page, my lord. In the cross-examination part, I recorded the statement of the said patient, Khurshida Bibi, at 17:35 hours. Before recording her statement, I consulted verbally with the doctor under which the said patient was admitted. So there is no question of going through the bedhead ticket, my lord. The doctor who was treating the patient was consulted, my lord. And after that, the dying declaration was recorded. And the existence of dying declaration is not disputed, my lord, because this fact is admitted in the cross-examination. This is not a voluntary statement, my lord. This is the cross-examination part where the doctor stated that he recorded the cross-examination. More so, my lord, coming to the evidence of the father of this victim lady, my lord. Here, at page 13, my lord, of their application. Just before the cross-examination part.
Yes.
My lord. She told me that her husband and parent-in-law and brother-in-law, after pouring kerosene oil on her person, set her on fire, my lord. This is the first declaration, my lord. So there are series of declarations, similar declaration, my lord. There is a corroboration, my lord. So at this stage, my lord, whether there is a certificate or not is immaterial, my lord. That can be gone into during the hearing of the trial. The reappreciation of evidence in the 389(1) stage is not applicable, my lord. My lord, moreover, my lord, I rely upon here the principle of law.
Two things.
Yes, ma'am.
Apart from the doctor,
Yes, ma'am.
at the time of dying declaration, the wardmaster and a staff nurse
Yes, ma'am.
were they examined?
Yes, ma'am.
What is their statement?
Okay, number two. They were examined. I found it in the judgment, my lord. They were examined.
Medical witness only one, PW 9, Subroto Halda.
My lord.
And defense witness, defense also.
Examine
of
witness, my lord. পুরো evidence টা দাও না।
Three medical witnesses. Defense,
পুরো evidence টা
there
দাও।
was a defense witness also.
The full evidence is not here, my lord.
Court witnesses, whether it is the order. Oh.
May I proceed, ma'am?
Well,
May I hand up a judgment of the Honorable Supreme Court on this point, my lord? This is a case of similar nature. My lord, here in this case, the principle of which, my lord, when the principle of
oh, yes.
criminal law is that during the bail, my lord, there is a strong presumption of innocence. Bail pre-conviction stage, my lord.
Oh, 2020 টা? 2020.
Yes, yes, my lord. Yes,
Singh,
it's a Pitpal Singh judgment.
Yeah,
Sir.
2020,
When there is a conviction by a competent court of law, there is a presumption of guilt, my lord. So there is overwhelming evidence. A dying declaration is there, my lord. I humbly beseech your lordship to. So life imprisonment is there, my lord.
This application has been presented under section 389 within bracket 1 of the Code of Criminal Procedure.
Corresponding to 430, তাই তো?
Corresponding to 430.
430 subsection 1.
Subsection 1 of PNSS.
ভারতীয়
2020.
পুরোটা দিয়ে দেবে ভারতীয় নাগরিক ন্যায় সময়
ভারতীয় নাগরিক stopped in connection with an appeal registered as CRA within bracket DB number 43 of 2024. Stop. The appeal by preparing this appeal, the agent applicant challenge the legality and or propriety of the judgment of conviction and order of sentence passed by the learned order of sentence dated order of judgment of conviction dated date of
respectively dated for
also dated date of judgment is 20th May 2024 and 21st May 2024, comma respectively in sessions case number 21 of 2020. Stop. Mr. Ghosh, learned advocate defending the applicant submits that here the session case was initiated based on a complaint that the victim was that the accused person, including her husband, sparked kerosene oil on her person and then set her on fire. Stop. This incident claimed her life. Stop. Following the following such death, the patent case was initiated. Stop. He submits that it is a mere accidental death one, and the husband also got severely injured and subsequently succumbed to such injuries. Stop.
And died.
succumb to his injuries, to that injuries. He submit that here, the entire conviction has been based on the dying declaration. Stop. Although, the evidence, although the evidence of the doctor who recorded dying declaration of the victim, who allegedly recorded dying declaration of the victim, does not inspire confidence. Stop. He draws our attention to the seizure list, bedhead ticket, and the postmortem report and bedhead ticket and claim that in all those documents it was recorded that the victim suffered accidental burn injuries. Stop. He claims that subsequently this dying declaration was implanted. And the petitioner have been convicted. Stop. He submit that.
He refers to the,
He refers to the judgment and
he refers to the evidence of a neighboring person, wherefrom it appears that the convicts were not present at the local, but were catching fish in a nearby pond.
His further submit that the prosecution cases result in many defects. Stop. And the appellant has
Was there any forensic test regarding kerosene and this thing? Kerosene,
At this stage, I had not.
He submit that
Possession of the entire record, my lord. That can be, I can assist you, lordship, on that point only after the paper books are prepared.
No kerosene, pot of kerosene oil has been recovered and seized in connection with this case. Stop. He submits that the appellant has a fair chance of success in this appeal.
And husband also made accused in this, my lord. Principal accused has been made in the husband is principal accused here. Who has died.
He submits that. But husband made accused person what will benefit him?
No, because the father of the, my lord, victim has said the husband has, my lord, the main culprit in this issue, and he also died.
He submit that in the given case, in the present case, the father of the victim lodged FIR implicating the husband of the victim also. So,
initial the complaint is based on dowry allegation, but there are no previous complaints.
although in the present case, the prosecution case was that the victim was subjected to cruelty and subjected to cruelty on demand of further doubt. However, prosecution has substantiated such a case. Stop. Properly, you say it. Other people he has a fair chance of success in this appeal. He submit that the bail may be given to the petitioner upon sentencing, upon suspension of sentence order sentence. Stop. Mr. Vishwas Lanet advocate repenting the state submits that the prosecution has successfully proved his case by adducing evidence before this court, and the learned court has accepted that evidence and convicted the accused person. Stop.
The pivotal evidence is the dying declaration.
He submit that pivotal evidence in the prosecution case is the dying declaration. Stop. The learned court found it to be acceptable, and we submit that the dying declaration can be based to hold conviction. Stop. Since there was no defect in the state dying declaration.
No, there is corroboration by other witness.
We submit that the evidence of the complainant was corroborated by other witnesses. And those evidence was found trustworthy, and accordingly the learned court has rightly hold conviction of the present accused person. He further cites a decision.
না আর একটা হচ্ছে he submits হচ্ছে দুটো আগের previous applications for suspension of sentence as well.
Two earlier applications were done.
Submits that previously, two applications presented by the petitioner for seeking suspension of order of sentence and grant of bail have been rejected by two different coordinate benches of this court.
And there is no new change of circumstances.
There is no change of circumstances.
No, there is a change of circumstances because there was a direction for speedy, my lord, hearing of the appeal, and direction of the paper book was also there. That has not been since last 1 year has not been completed.
Okay. Mr. Vishwas cites a decision reported in 2020 from 8 SCC page 645 packeted Prithpal Singh versus State of Uttar Pradesh and another to content that there is a difference between grant of bail under section 439 CRPC and suspension of sentence and grant of bail under section 389. Stop. We submit that in the former case, there may be presumption of innocence. However, in the latter case, such presumption is not available.
Compelling,
And we submit that there must be some strong compelling reason for grant of bail under section 389 within bracket 1 of the code. In reply, Mr. Ghosh submits that their direction was given upon the state to take appropriate steps to.
No, not on state, madam. No.
To prepare.
Paper book will be prepared by the office.
Not specific. Direction was given for preparation of paper book, but till the date.
For expeditious preparation of the paper book and early hearing of the appeal.
But till the date, no such paper book has been prepared, and we submit that.
Trial court records have come.
I don't know, madam.
We submit that the.
LCR has been received.
Stop. Had the learned advocate appearing for the respective party peruse the materials on record placed before us, including the judgment of conviction and order of sentence. Stop. In the present case, the present case was initiated based on a complaint that on demand of further dowry, the victim was subjected to cruelty, and subsequently the accused person sparked, but on the relevant date, the accused person poured kerosene oil on the person of the victim and set her on fire. set her on fire,
Set her on blaze করে দেয়।
set her on plate, and following which the victim died. Stop.
Died at the hospital.
Died at the hospital. Stop. Victim was admitted in the hospital on 27th December 2013, and she expired on 27th December 2013. Stop. The medical reports indicates that she suffered 90% burn injury. In the medical document as well as the PM report, it was recorded that victim suffered accidental burn injury. Stop. The trial court based on a dying declaration and certain other evidence to hold conviction against the agent accused person.
পোস্টমর্টম রিপোর্টেও কিন্তু হচ্ছে ওই অ্যাক্সিডেন্টাল ডে।
আচ্ছা স্যার, তার আগে লিখে in the postmortem report also it was recorded that the victim died due to burn injury, which was antemortem in nature and also accidental in nature. Stop. I said, it is also admitted position that the husband was accused person in this case. Subsequently, husband who also suffered burn injuries in the same incident
and was admitted in the same hospital.
And was admitted in the same hospital.
Died
On 30th.
Died on
Only she died 17th, he died
on 30th.
Same month.
27.
No,
27 died, my lord, the lady has died 27, and husband died 30th. After 3 days.
Oh,
30th.
30th. Husband died on
30th or 13th? 30th.
33 after 3 days, my lord.
Taking note of these facts and considering this aspect that there is no likelihood of early disposal of the appeal, we are inclined to grant bail to the petitioner. We are inclined to
grant bail by suspending the sentence.
By suspending the order of such sentence. So, in the accordingly, the petitioner.
For yes, Mr. Bishas, for how much time is the convict in custody?
My lord, he was more 13 months.
Huh?
13 months. 13 months only, my lord, post conviction.
The
Too early, my
petitioner
lord.
is in custody for 13 months without taking.
See,
note
now
of-
you are aware the entire direction of the recent orders of Supreme Court clarifying it, because initially Article 21 was taken into
Consideration.
account. You will find a division bench judgment of Justice Bagchi sitting with Justice Ghosh, where a distinction was made that only 21 will not help. You have to also speak on merit. But subsequent judgment of the Supreme Court has impliedly overruled that view.
And taking note that petitioner has made out a good arguable case in this appeal. And the issue raised by the petitioner in this appeal needs to be addressed. Because taking note and taking note of the fact that there is no possibility of early disposal of this appeal, we are inclined to. ঠিক আছে? আচ্ছা, তাহলে হচ্ছে two petitioners.
Two petition.
How much?
As your lordship desire, my lord. I will not say.
As your lordship
As your lordship desire. Whatever the, my lord, your lordships feel fit and proper, my lord, I am agreeable.
Huh?
20,000? As your lordship. With two CUTs? As your lordship. Local? No problem, my lord. There is no issue, my lord. Two. The petitioners may find bail of rupees 20,000 with two securities of 10,000 each. ঠিক আছে 20,000 each করবেন of 20,000 each with two securities of 10,000 each, one of which must be local. With further consideration, you don't leave.
ওইটা হচ্ছে ওই দুটো জিনিস করে দিন as to report every 10 days, every 7 days করে দিন report 15 days করে ঠিক আছে 15 days and shall not leave the local jurisdiction without specific intimation to the officer in charge of Kotwali, some
Kotwali police station.
Kotwali police station.
Which way?
15 days.
Report to the police. Now there is no IO now. It's then the IC.
Yes, that's the local. Yes, ওই হয় অফিসার ইনচার্জ জানি না
Inspector in charge. Inspector in charge or officer in charge? Station head, IC. Station head.
ওই দিয়ে দাও আইসি অবলিক অফিসার ইনচার্জ ইন্সপেক্টর ইনচার্জ অবলিক অফিসার ইনচার্জ because we do not know many of the police stations sub inspectors are the officer in charge and some the inspector
Number of ICPS.
Odor is meant by inspector.
Yes,
mainly.
Inspector. Inspector in charge. We have been told that here TCR has already arrived.
Yes.
Has already arrived, stopping that event as the office is directed to take directed to make sincere report.
Expeditious steps to prepare the expeditious steps to prepare the paper book. The parties will be at liberty to mention the matter for mention the appeal for being enlisted for hearing immediately after the paper books are made ready.
Well, let there be another direction for preparation of the paper book as soon as possible. I don't think it's 6 weeks yet.
Can be spoken.
Then 3 months.
NCR has come. NCR,
yes, sir.
Now NCR cannot be. TCR has come.
Yes, sir. Now get food.
Okay, that direction will be suffice. Will suffice. I'm not feeling like
Good.
Appealing for the application or showing the letter, the depositions of the witnesses not this week. Very much required, Lordship. Kindly take it on Thursday. In the meantime, I will go.
Why Thursday?
31st of
Last day, penultimate day, you do it. If you can get it tomorrow, you can get it day after tomorrow.
Well,
What do you, who is for the estate? Yes?
he's honest. Working Chaudhary or that.
Ask him. We are passing it over. Let Mr. Chaudhary come, we will fix the date.
Yes, come.
Yes, come.
Yes.
Yes, do you have do you have the copies of the deposition?
No, my lord.
Yes.
Because he says that he wants to rely upon the depositions, the entirety is not there.
Then copies are required then. আমাকে অ্যাডভান্স করতে হবে। Wait for
Item number 3. Under the heading admission of criminal appeal. Item number 3.
Passover code. Who is appearing for the state in this matter? Item 3. দেখো তো ফাইলে কার কি অ্যাডভোকেট কে আছে? হ্যাঁ? স্টেট না, পিটিশনের অ্যাপেলেন্টের অ্যাডভোকেট কে?
Subhashis Mishra, Mr. Suprajit Pal, is Sweya Shokha.
Oh, Mishra. Who are you, Mishra?
You are appearing. Passover করো।
Item number 4. Under unanimous appeal.
I represent state in this matter, Lordship.
Passover করো এই তো।
Lordship, on the previous occasion, there was a direction by this court to serve notice upon the respondents. We have duly served. Mr. Deboshi Dhar had retired from this matter.
My lord, item 5, your lordship, I appear for the appellant.
This is item number 4. This is item number 4.
Sorry.
Passover করো আর কি হবে?
In the last occasion, there is a direction to serve the intimation to the petitioner lordship. This is the intimation.
কি করবে?
You are part of the appellate? No. We are the respondent.
Appellant আসছেই না।
Appellant is not coming.
What is the matter about?
This is a police in action matter.
They are seeking for the quashing of the FIR lordship.
By preparing the
Charge sheet has been submitted.
No, charge sheet submitted.
Yes. Charge sheet has been filed.
ভজন লাল।
Yes.
1992 সুপ্রিম কোর্ট।
কোথায় এটা charge sheet?
ওটার পরে নিখিল মার্চেন্ট এসেছিল, তারপরে রিসেন্ট আর একটা এসছে। Yes.
Better, I will appear in this case. If your lordship kindly want
No.
a petition.
You will appear, the contingency.
For item number 4, lordship.
Instruction received, but material instruction not received.
Lordship, I have instructed. Kindly make it note, I will.
এই যে, এটা ইয়ে করো, একটা অর্ডার রেকর্ড করো। Pursuant to the direction given by the order dated 9th June 2025, the learned advocate for the state has served the appellate who remained unrepresented on that day. Mr.
Satyajit Pal.
Mr. Satyajit Pal, learned advocate, appears and submit that he has the instruction to appear on behalf of the appellate. Mr. So is for an adjournment. Let this matter appear Kalkin list. Tomorrow don't embarrass us.
Lordship, in the writ matter, he had duly appeared.
Appear on this matter in the writ petition, Lordship.
He has the instruction.
Faithful, Lordship.
Great.
His fees were not paid, so he has refrained to appear. Now there is an adjustment. Past dues paid, assurance of the present. He is now again coming and appearing.
Grateful.
Grateful, Lordship.
She may indulge with regard to item number 3, Lordship. It was passed over. I am appearing.
Yes, we were seeking for who is for the state. The state was there.
The admission stage.
Yes, who is for the state?
On the last occasion, my Lord, Mr. Arjun Chaudhary was appeared.
You sent for Mr. Chaudhary?
Lordship, I will-
Take it up, no difficult.
Lordship.
Item number 3.
3, Lord.
3টা কি হয়েছিল? Passover হয়েছে? When Mr. Chaudhary was there, he appeared in one of the matters. Item 1 probably. 2-তে না? You talk with Mr. Chaudhary, I will.
Item number 5, under mandamus application.
My lord, Mr. Amritam Mandal will appear
My lord,
virtually. My lord.
I appear for the appellant, your Lordship.
Yes.
I am,
My Lord, this is the matter.
I am
Yes.
for respondent number 1, your lordship.
My Lord, this is a matter wherein a contempt petition has been filed for, my Lord, alleging, my Lord, disobedience to an order dated 29th of January 2024, wherein the municipality, Mal municipality has been directed, my Lord, to pay the amount of the writ petitioner. My Lord, I being the chairman of the Mal municipality, I was under an obligation at that point of time to pay the amount. But no
What is the where is the
Yes,
impute order?
my Lord. It is at page 17. Annexure A kindly comes. My Lord, the impugned order is thereafter, my Lord. The impugned order is on 3rd of April 2025, wherein, my Lord, the learned single judge had, my Lord, directed me, the erstwhile chairman in his personal capacity, to file, your Lordship, the affidavit of accounts.
Yes.
So I am challenging that
Just,
order before your Lordship.
Mr.
Yes,
Mondal, will you
yes.
give the facts in some more details?
Yes, your Lordship, I will. Your Lordship kindly comes to page 17, your Lordship, once. My Lord, prior to that, my Lord, before I take your Lordship to the intricate details of the matter, my Lord, I am told that contempt petition is being, my Lord, is to be taken up on 19th. That is, my Lord, there are 2 days thereafter, 2 days after. My Lord, almost all the payment has been made. A fraction of it, 1/3 of the payment is left out. So, my Lord, if that is paid by the municipality now, this whole contempt and the appeal pertaining to the contempt all will become infructuous.
No,
So,
who says?
Okay.
Complying, there are Supreme Court judgments. Complying with the order does not disentitle you from proceeding with the appeal.
Very well.
There is a judgment, if I correctly remember, of Justice Nirjar, sitting with whom I exactly do not know, but it has been clarified that contempt does not link it with the appeal. Even if
No,
you,
no,
if
no,
you, even
no,
if you comply,
if my lord, the contempt is not anymore over there. My particular order challenging the one of the orders of the contempt wherein my personal assets have been directed to be filed. I'm challenging that order before your lordship.
what is the money, on what account the money has to be paid?
Yes, my lord, kindly comes to my lord the order where from the contempt, my lord, follows. Order dated 29 January 2024 of the writ petition, my lord, page 17. At page 18, my lord, the 3 paragraphs said,
Just
my
tell
lord,
me.
yes. If I may read out, my lord. Yes. My lord, at page 18, my lord, the first paragraph itself.
That order has been affirmed by division.
Yes.
No, no, I'm not challenging this order. My lord, what I am saying, my lord, from this order is that direction has been given upon the municipality to pay, to clear the amount.
So who will pay?
The municipality will pay. My lord, thereafter, my lord, kindly sees, my lord, immediately thereafter, my lord, at page, my lord, at page, my lord.
The respondent, private respondent executed certain work.
Right.
So against that, he is entitled to a
Payment.
payment of an aggregate bill amount of some 37 lakhs.
25 lakhs. 25 lakhs.
25 lakhs is the ascertained amount.
No, the direction has been given to the municipality for payment of 25 lakhs.
See, Mr. Mondol, your client is not doing any charity.
No, no, no.
Yeah, they have received the work.
Yes, my lord, I bow down to that. I'm not complaining against that.
Let us see the color of money.
Yes, my lord, I'm not complaining, my lord.
How much did you pay? How much did you pay?
I'm telling you, my lord, this order was passed, if your lordship sees, at on 29th of January 2024. Thereafter, my lord, 8 lakhs and odd has been paid in the month of December. After the contempt was filed, my lord, at my time when I was the chairman, I could not pay because of paucity of funds. Contempt petition was filed on my lord, December, in the month of December, my lord, 8 lakhs upfront have been paid once we have received the money. Thereafter, my lord, on 29th September, my lord, prior to that, I was suspended from the party, and my lord, the entire task, the entire, my lord, duties of a chairman has been shifted to the vice chairman. I have been made to resign from the post of chairman. That also I have stated. There was.
We are not interested to hear passing of the buck. 25 lakhs was directed to be paid. Now that was confirmed in the appeal. Nothing remains.
No.
25 lakhs you have to pay.
Yes, not me, my lord, the municipality. The municipality, my lord, I am the erstwhile chairman.
See, you means the municipality. We want to mean the municipality.
No, my lord. Kindly seize the order. The order says the municipality needs to pay. Municipality out of 25 lakhs have already paid near about, my lord, 7 to 8 lakhs are due as on date.
Mr. Mondol, I have read the order.
Yes.
What gives you a view that I have not read the order?
No. Your lordship has read it in absolutely. Your lordship.
25 lakhs was directed to pay. You are being the then chairman or being the in charge of the board of councillors of the municipality.
Right.
You had a responsibility.
Absolutely.
But the work has been done for the municipality, so the municipality is required to pay.
Right.
Now, today, where is the money?
Money,
Who is
money,
appearing-
money
who is
has
appearing
already.
who is appearing for the municipality? Why you are interested so much?
No. I am interested because by an subsequent order dated 3rd of April, my lord, I have been directed by the learned single judge, the judge before whom the contempt proceeding is pending. My lord, he directed me to file my personal affidavit of accounts, affidavit of assets. I am aggrieved by that order, your lordship. I have already filed an affidavit of compliance in the contempt petition saying that it was outside my purview and scope, my lord, after being thrown out from the post of the chairman, after being suspended from the ruling party, my lord, I am not in a position to pay the funds from the municipality. The direction was upon the municipality and the municipality thereafter has also paid.
How
So-
much did the municipality, who is for the municipality?
6 to 7 lakhs are due as on date, my lord, as I am
Where
told.
is that order?
My lord,
My lord, kindly seize.
Whereby you have been asked to,
the one copy is available.
3rd of April, your lordship, kindly seize.
Your appeal is directed against which order?
Yes, my lord, my appeal is directed against an order dated 3rd of April, 2025.
Copy of the order has not been annexed.
yes, I am trying to find out. And you come to your.
No, my lord, it is, my lord, may I? Just a moment.
Where is that order? Have you annexed it?
No.
Hand it over.
No.
My lord, it's annexed with the memorandum of appeal, your lordship.
Memorandum of appeal.
Yes. My lord, 3rd of April, 2025.
Yes.
Even in the memo of the
After this order was passed, there was also another mode of payment which was done by the municipality. On 13th of May, they paid 6,73,653. So 8 plus 6 is 14. 14,73,000 they have paid, the municipality.
Where is the balance amount?
My lord, balance is 7 to 8 lakhs, my lord. That the municipality, I am told, my lord, 19th is the next date of the contempt application. They will pay before that date. That is what I am told.
Yes.
That is,
Why photo? How much did you pay?
We have paid an amount of 21 lakh or 700.
Yes, yes, you are for the petition, appellant. Now,
my lord,
what is being stated is correct. 21 lakhs have been received by your client.
My lord,
You are for the,
Contractor.
contractor.
you have received 21 lakhs.
read petitioner.
When will you pay the balance amount? Yes?
Next week, 19.
My lord, I am told the contempt is on 19th. So I am told they will pay before 19th. That is what I have told, been told.
কুড়ি তারিখ রাখ। See, if the money is paid, then probably the court will not insist upon production of this particulars.
Yes.
এটা 20 তারিখ রেখে দাও।
Very well. Deeply obliged, your lordship.
My lord, may I hand over the affidavit of service?
Keep it with you.
Keep it with you on that day.
Item number 6. Under manual application.
Chief, I am for the petitioner. If service has yet not been affected to some respondents.
When did you file?
Chief, I have filed at 9th and made a service on 11th.
Answering respondent are the state, my lord, and we are ready, man.
Keep praying for a next circuit. Actually, Lordship, this matter is led by Manoranjan. Das.
We are not interested who you are led by whom or what. Do the matter, let us hear it out.
Praying for a 2 days accommodation.
2 days, 3 days,
Lordship, 2 days.
My lord,
application.
I will not,
I will inform.
5-star, 4-star accommodation, we are not interested.
Lordship,
here grievances regarding my
Lordship,
lord, the
may I-
issuance of a
May I?
petrol pump license, my lord, to
Lordship.
carry out their business. DM Alipurduar has refused to provide that license as they were asked to provide the details of the land on which the petrol pump exists. They could not provide any
no.
document, my lord. Even the PPCL in the read court has stated that the land is no more under their control. Now they
No,
have
no,
come
Lordship.
before this
Lordship,
court.
may I submit, Lordship? Lordship, being a licensee holder of the, under the Petroleum, Bharat Petroleum, I have been continuing since Lordship 2006. More than 2006, I have been continuing, and thereby I have been producing my relevant documents. License will be issued regularly, Lordship. At the same time, I was running my business, Lordship. And being a licensee holder, Lordship, I was also renewing my spirit license. MSHSD license, Your Lordship. And what happened, Lordship, at in the year 2019, when I again went for the renewal of my license, they called for me that the renewal of my license, they asked for me that they made an inaction regarding that, and further apprising the same, they asked me to pursue a certain documents, Lordship. After which I have produced all the relevant documents which I was producing since 2006. Every document, each and every documents. What happened now, Lordship? The respondents herein, what they have asked to seek a certain documents which was not in my control. Being a lease holder, Lordship, the lease was made to me by the Bharat Petroleum. So what does, I have filed all the necessary documents. There was been called for the documents in respect of the Lordship conversion of the land. Land has been conversion of the land, and Lordship regarding the Khutian. I have submitted it regarding the land conversion, Lordship. Being a leaseholder, Lordship, already the NOC was been derived by the predecessor who was under the lease. That has also been, Lordship, taken on record. But in spite of, Lordship, they has not providing me the license, neither the trade license for which I could run my business, Lordship. I have submitted every application. If you lovely kindly consider the CAN application, I have detailed annex the documents. The matter is herein due to the non-issue of the trade license, my spirit license has not been renewed.
The land is belong to whom?
To Petroleum, Bharat Petroleum.
No, ma'am.
I am under the lease, Lordship. There is a documents which are annexed in it. I am being a leaseholder running a Petroleum, Lordship. License holder, Lordship.
License holder, but you show that you have a right to utilize that land.
Lordship,
To
I have-
carry out any business or to operate a petrol pump.
Lordship, I have been annexed every documents. It has been
Not
annexed.
documents show that
Lordship,
they
Lordship,
are,
kindly.
they
no,
have
no,
the
no, Lordship.
utilization right.
No.
Because the
Lordship,
land
kindly-
belongs to one person, they have, that person has entered into agreement, lease agreement with one refinery. Refinery is done, my lord. They have entered into a lease agreement with Bharat Petroleum.
Petroleum,
Bharat Petroleum entered into a license between them. But the land which was taken was by the refinery.
Lordship,
And
NOC
before
was-
the trial judge, my lord, the refinery categorically stated the land now at present does not belong to them.
No, Lordship. The
Kindly
land-
see the order.
Kindly see the NOC, Lordship. It was been derived regarding the conversion of the land. NOC was been granted by the DM or by to the leaseholder, Lordship. It was been there, Lordship. Lordship,
Only question is whether the land belongs to them or
no.
Or they have
I am
got
a
any
leaseholder,
paper
Lordship. I am a leaseholder. I have
of the
every
leaseholder of the land.
since 2006, Lordship. I am running my Petroleum, Lordship.
You come to para 6 of the impugn order.
Lordship,
What courts have said.
Lordship, my
Admittedly, there is a dispute regarding the with regard to your right.
no, Lordship. Lordship.
Again, we are here without hearing what court will say. You are started saying no. There is a dispute, court observe. There is a dispute with regard to the right of the petitioner to carry on trade from the subject plot of land. Admittedly, there is a dispute regarding the plot of land, whether you have any right to use the land to carry on any business from that land. It is the dispute. It is the subject matter of the dispute. And hence the DM has denied to issue a trade license.
Lordship, may I
DM is the authority, he will issue a said license and authorize you to carry on a business from a land, you have a specific right to use the same. Huh? DM is to ascertain. Now what, no document has been annexed to the writ petition, from where the right of the petitioner who are subject land can be asserted. You just show that as on date, you have a right to use that land to carry on any trade or business from that land.
Lordship, may I kindly it is the CAN application.
And court has given it to it will be open for the petitioner to take appropriate step in respect of subject land in accordance with law, if so advised. It will also be open for the petitioners to sue the oil company for violation of any contractual obligation.
Lordship, may I make my short submission, Lordship, regarding that?
Now you are claiming that Bharat Petroleum has authorized you.
Authorized me, Lordship.
Actually, Bharat Petroleum is not the owner of the land. Bharat Petroleum was the original lessee of the land.
No, my lord,
Lessee
not,
of the
not
land.
original lessee, my lord. They were given lease by the refinery.
Or by the refinery.
Yes.
That means
Lordship, that has
Very
they have
well.
been merged. It has been merged.
Let them serve a copy on BPCL. I appeared for the BPCL. I appeared before the learned
Oh,
secretary.
where the shoe pinches that we are not be able to understand till now. Why are you aggrieved by the order? Can you tell?
Lordship, may I make my
Yes.
Land
Lordship, land was been granted to the land was been first of all granted to the refinery. Thereafter, by way of lease. Thereafter, it was granted to the Bharat Petroleum. No. The refinery made an agreement
Originally, Millard.
Refinery or retail outlet? Petrol pump.
Maligaon Refineries Limited, NRL was the original license, the licensee.
in respect of the land.
In respect of the land, NRL granted them a license to run and operate a retail outlet. Subsequently, all assets and liabilities of NRL merged with Bharat Petroleum Corporation. NRL ceased to conduct any retail operation, save and except their refineries, which is there in Assam. So according to that arrangement, BPCL took over all the retail outlets, which were earlier operated by NRL. Similarly, Assam Oil, their retail outlets were given to Indian Oil Corporation. So that's how BPCL came into the picture. Now, BPCL was merely issuer of a license, dispensing pump and selling license, DPSL license, in terms whereof they are supposed to operate the retail outlet. But so far as the land is concerned and all statutory liabilities, the licenses under the petroleum
Are of
etc.,
BPCL.
were their obligation to obtain.
Yes.
BPCL was only the licensee for granting them a dealership, because without a oil company dealership, they cannot operate a retail outlet. The land belongs to someone else. That is recorded as Dhaba probably. And on that land, they were running that retail outlet. BPCL today has nothing to do here. There's not in the picture.
No, so he is the
It is in between them and the state.
He is the leaser. I am the licensee holder under his agreement. Your Lordship.
Yes.
Maybe none is going to.
What are you asking for? What are you asking for?
My trade license, kindly, Lordship, considering for my trade license.
Trade license.
Trade license, motor spirit trade license. Street license.
We need land.
No.
Single piece of land. Either a rent receipt.
You are for the
State matter. They have to provide any land document like rent receipt or a lease agreement, anything. Let them provide, we'll provide it.
Lordship,
We'll give the license.
No, Lordship, I have every document.
Because previously, the refinery used to give those documents and DM has issued earlier occasion.
I am Lordship.
Now,
one day
while renewal, when they were asked, they failed to
one day
provide.
accommodation.
Even the BPCL could not provide.
Court has kept the window open for you to clear the dispute.
They had to
You
clear.
approach the original owner.
No, Lordship, they has misreading my submission. My submission is, Lordship, I was being under lease agreement with the Bharat Petroleum and which has been still in force. which is still in force. Lordship. My license is still 2026.
You have understood.
ওর
License
যেটা হচ্ছে ওই মোটর স্পিরিটের লাইসেন্সটা মিউনিসিপ্যালিটি দিচ্ছে না বলে ডিএম দিচ্ছে না দিচ্ছে না বলে
of the trade license.
ও পাম্পটা অপারেট করতে পারছে না ও বলছে বিপিসিএল এর কাছে সঙ্গে আমার এগ্রিমেন্ট আছে কিন্তু মালটা বেচতে গেলে আমার ওই লাইসেন্সটা দরকার এবার লাইসেন্সটা দিতে গেলে ডিএম বলছে জমি কোথায়
Yes.
No, there is an NOC already been granted to that.
Original
NOC.
owner of the land.
Original owner regarding the DM has granted.
Original owner of the land has given a permission or given license to use his land. You show any document?
Lordship, I being a licensee holder, how can I have been under granted a license?
নরমালি হয় কি বিপিসিএল ইয়ে করে তোমার
They take the land in lease and they
নরমালি হয়েছে বিপিসিএল নেয় জমিটা দিয়ে ওটা হচ্ছে জমি সমেত ওই আউটলেটটাকে অপারেট করবার থাকে এবারে অনেক ক্ষেত্রে দেখা যায় যে যে জমির মালিক সেই হচ্ছে পেট্রোল পাম্পের ডিলারশিপ পাচ্ছে আবার কোথাও হচ্ছে থার্ড পার্টি হয় এবার এই যে নুমালিগড় দেখবে 87 সুপ্রিম কোর্ট যেখানে হচ্ছে প্রথম এলো ওই ভারত পেট্রোলিয়াম বার্মা শেল ওখান থেকে কি রিপোর্টেড জাজমেন্ট সুপ্রিম কোর্টের ঠিক আছে 87 কিভাবে কি হলো কোন কে কি পাবে ওইগুলো ঠিক আছে এবারে জমিটা কার সেটাই তো বুঝতে পারা যাচ্ছে না
and the landlady has submitted a written complaint before the DM. Written complaint before the DM. Relative my lord.
Intra-family dispute.
Actually, Lordship, the NOC already was been granted by the district magistrate to the refinery already for the keeping of the storage of the permission.
Going to that, mere license from oil company will not do. Permission from the owner of the land is required. Have you got?
Lordship, give me one.
Then direction can be given upon the DM
And,
issued license.
That's one day accommodation I will.
One day what will be?
Lordship, kindly, Lordship,
No,
allow.
you are running to document. So
No,
No,
Lordship.
the
I will-
let us understand the facts. Probably you are not properly instructed. Let me understand the facts. Now land belongs to whom?
Land belongs to one.
Your relative, someone lady. Doing
No,
some,
Shivani Das-
some,
land belongs to Shivani Das Bhome.
Now, how did this land come to him? Because he
No. Land was given on lease to the refinery. Thereafter, my lord, refinery, after merger, my lord, they enter into a agreement between the BPCL.
Ah,
So this lady, in the said lease agreement, there was no condition for sublease. I don't know how they have subleased it.
sublease. Statutory 87 Supreme Court, statutory এটা.
Even if it is my lord statutory right,
Statutory, because
then
see, whenever this transfer takes place, the transfer takes place with the land, the lease. Because I am sure, I give you this. ডিসপিউটটা কি জানেন মধ্যিখানে আমি আসল কথা বলে দিচ্ছি ওরা বলতে পারছে না বিপিসিএল মধ্যিখানে বিক্রি হয়ে যাওয়ার কথা হচ্ছিল ওই সুযোগটা নিয়ে ভেবেছিল জমিটা ছাড়াবে না হলে ওটা হচ্ছে স্ট্যাটুটারিলি চলে যায় জাস্ট
আমার কাছে একটাই আছে
বলে দিচ্ছি
না আমি অফিসে ইয়ে করেছি
Bharat Petroleum, Burma Shell, 87
Petroleum Burma Shell.
হ্যাঁ 87 সুপ্রিম কোর্ট আছে আর এখানে লেখা নেই মানে একটু খুঁজে দেখতে হবে এই খাতায় বোধহয় লেখা নেই AIR রিপোর্টেড AIR 87 এ রিপোর্টেড আমার যতদূর মনে পড়ছে দেখি খুঁজে দেখি
Then my lord, the refinery did not change the nature of land. There was a condition that
See.
they will change the nature of land.
No. The dispute is, see, if you look into the history, this is based on this 87 Supreme Court. I am absolutely sure this is based on initially the oil companies were private oil companies. Now after independence, they got nationalized.
76.
Now, that is under the 76 Act. Now, when these assets of the oil refineries were nationalized, they vested in the state. Now, subsequently, the state gave it to, say, BPCL, HPCL, Indian Oil, and it was the land with the permission. So whatever was the asset of the say Burma Shell, I am speaking because Bharat Petroleum came from Burma Shell. So whatever was the asset of Burma Shell was given to Bharat Petroleum. Now these so when Rumaligar gave it to Bharat Petroleum, it must be under any statutory recognition. And if that be so, then the land with the license got transferred. So the lessee, Rumaligar, instead of Rumaligar, BPCL steps into the shoes of Rumaligar, they become the lessee and they have allotted the license of operating a retail shop by the appellant. Now, the appellant requires the motor spirit license. Now, if the landlady is, say, dissatisfied, she has not taken any steps. Has she filed any forfeiture case? No forfeiture of lease. Then why DMU are standing in the way?
Well, we need the land because the PPCL before the trial judge has stated that they have nothing to do with the land.
Sir,
So if
this is misconception.
Well, then it has to be, let the.
See, the land was of Numaligarh refineries.
I know.
Now, Numaligarh refineries assets were transferred.
No. Land never belonged to Numaligarh refinery.
No, they were the lessee.
They were the.
No. The land always belonged to a private party.
See, owner, see, Mr. Ghosh, I tell you, I will give you the full picture. Say, Shivani Ghosh Bhomik or our predecessor was the owner. Now, there was a lease agreement between the Bhomik with Numaligarh refineries.
Lordship.
Has to be.
Lordship, there is a document.
Two, three different models of operating.
There is
of
an
retail
agreement
outlet.
also I have annexed.
This is not a company-owned retail outlet.
No, that is Coco is something different. Coco is something different.
Company-owned, company operated.
Coco is something different. It's not that. The land all over West Bengal, you will find that the land is owned by, is under a lease agreement to the oil company. Now, oil company allows a licensee to operate a retail pump, retail outlet on that plot of land. The lease rent is required to be paid by the oil company to the owners of the land. And he will be selling the products, he will be depositing certain sum of money as the licensee to operate the dispensing unit. He will be selling the other products for which he will be getting a commission. This is the model. Now, this owner says that after Numaligarh, I do not recognize BPCL. And BPCL washes his hand, but it's not a case.
Right.
It's not a case. The moment there is a lease vis-a-vis he, see, the law is different between Shivani and BPCL. It is a lease governed by the Transfer of Property Act. Between the oil company and the licensee, it is governed by the Public Premises Eviction Act. So, whenever you suspend their license, you can, under that act, remove him also. This is the whole concept. Now, when there is a transfer, Numaligarh transferred under, how did Numaligarh's assets came to BPCL?
It's a case of merger.
Merger. So if it is a merger, either merger can take place by statutory provisions approved by the legislature, or it can be a court order merger. In any case, whether it is a statute, in any case, the with the merger order or amalgamation order, the property will come to BPCL.
Yes. But there is a third model also, where the land belongs to the owner never transfers the land to the oil company. That is called seaside. The company only executes that agreement so that he can sell and operate his.
That is the owner is himself or herself.
Himself is a deal.
Yes, license. Owner is the owner of the property. Owner of the property, and as also is enjoying the license.
Dealer.
Yes, that is a different. But here there is a dispute.
Admitted correction, Millard. This is the case of the third category.
No, Lordship, no.
Can't be. Can't be.
My instruction, Millard, as far as I can recall, this is the case of the third category where the land was never vested or given either to another.
Cannot be. Otherwise, a third party cannot become a licensee.
Yes.
If Bharat Petroleum, or for that matter Numaligarh, did not have a right over the land, they could not have given it to his client.
Since 2006,
No. They are carrying it under the name of NES Hasimara, where probably she is also
under the licensee of the under the license granted by the Bharat Petroleum. And Lordship, regarding the NOC, it has been.
You are not properly instructed on facts. What do you? The court has to frame your case.
Millard, let him serve me a copy. Millard, let us come back on Wednesday. Well, I will appraise your lordship.
So I will consider my lordship as rightfully honest. I will make my submission, lordship, correctly if the lordship will today, sir.
এই মামলাগুলো আমার করা আছে বলে এখন এটা ধরা যায়, না হলে যে করেনি তার কাছে কেলেঙ্কারি হয়ে বসে থাকে, কিছুই বলতে পারে। তার জমি কে যাচ্ছে আর ডিএম মধ্যখান থেকে মাতব্বরি করছে। ইয়েতে দেখবেন রিপোর্টের জাজমেন্ট
খুঁজে পাচ্ছি না, বার্মা সেল BER
বার্মা BUR MA বার্মা সেল, ওটা ওটা 76 এ ওই SHELL ওটা SHELL বার্মা সেল।
রেসপন্ডেন্ট, তাই তো?
না, এটা ছিল বার্মা, এটা ইউনিয়ন অফ ইন্ডিয়া ভার্সেস কি একটা ছিল ও মানে এটা ছিল হচ্ছে ইয়ে হ্যাঁ হ্যাঁ ও 87 আমার কাছে একটু দেখতে হবে অন্য খাতায় লেখা আছে
Moreover, my lord, the lease agreement is required in this matter. From the day one only, I was asking for the lease agreement. There was a direction upon Mr. Ghosh to come up with the papers of the lease agreement. But thereafter, my lord, he submitted that the land doesn't belongs to them.
No, the lease agreement, everything is annexed here.
Where is the lease agreement?
It is here in the CAN application.
Where is the lease agreement? Let us
Tell me, page number.
156 lordship in CAN application.
One
150
156.
156 starts from the agreement, lordship. It's between the owner and the refinery.
Do you have legible copy?
I have annexed
It will
everything.
definitely.
এটা আছে। The documents will call for on.
just a minute. It is 12 June 2000. What is the year? 12 June 2000. What is the tenure of the lease?
For a period of 30 years. 30 years. 2006.
12 June 2006.
ঠিক আছে যেটা বলছেন দেখো পেয়ে যেতে আসে নোমালিগড় ইয়ে মানে এও জানে না মানে
Lease agreement.
বলছি তো
Shivani Das Bhumi.
নোমালিগড়
It's a lesser. One part. And or Numaligarh Refinery Limited. It's a lessee.
হ্যাঁ
2984 square meters.
এবার 30 বছর আছে দেখো ওই যে চলে এসে ওই
Tenure of the lease.
4 নম্বর ইন্টারনাল পেজ 160 এসো
Yes. 30 years.
30 years 2006 থেকে 30 years মানে
2006 to 2036.
36
2036, my lord. There
Twen-
are page 169, my lord. The deed of transfer and assignment.
yes what deed of transfer and asset
The Rumaligarh has transferred it to the.
what is the interest I'm we are unable to understand what is the interest of the district magistrate.
My lord, until
Thereafter,
previously, my lord, it was offline. But now, my lord, we have to produce a rent receipt or a agreement. A document is required, my lord.
Very well, document is required, no difficulty.
My lord, kindly, this is a Petroleum license. Now, if something happens, who will be responsible?
I have the lease driving lordship.
Who will be responsible, my lord?
Just a
The
minute.
first person will be who has granted the license.
No. See, in our country, don't show us executive officers taking responsibility.
So Shivani Das was the original owner. He executed lease.
Numaligarh.
Numaligarh on in the year of 2006 for 30 years. That is lease existed till 2036.
Yes.
236 years. Now Numaligarh executed deed of assignment in favor of Bharat Petroleum Company Limited. Now Bharat Petroleum issued a license.
দেখো এইবারে হচ্ছে কি অ্যাসাইনি, ঠিক আছে? এবারে এই যে অ্যাসাইনমেন্টটা হলো, এই অ্যাসাইনমেন্টটা আন্ডার হোয়াট অ্যাক্ট? এই দেখো আমাদের ডিড অফ ট্রান্সফার, এই আমি দেখিনি। ওই তো রেসিডুয়াল লিজ হোল্ড রেন্টটা, রেসিডুয়াল লিজ হোল্ড।
লিজের রাইটটা অ্যাসাইন করবে, লিজের রাইটটা অ্যাসাইন করবে।
না, রিনিউয়াল করা হচ্ছে।
লাইসেন্স দিয়েছে
ভারত পেট্রোলিয়াম
লাইসেন্স টু ইয়ার নাম সুদীপ্ত হালদার।
পুরো জিনিসটা পরিষ্কার হলো এখন, যেটা বলছিলাম। এবার এটা স্ট্যাটুটারি হয়নি, এটা হচ্ছে ওই ৬৯ লাখ টাকা নিয়েছে দিয়ে অ্যাসাইন করেছে। ওই
কোম্পানি hereby grant license up to the license for a period of 15 years and renewable for further for 5 years each time at the sole discretion of the company.
কবে দিয়েছে দেখো,
এটা memorandum of agreement 27th August 2018.
হ্যাঁ, তার কারণ হচ্ছে এই ডকুমেন্টটা দেখো, যখন অ্যাসাইনমেন্টটা হয়েছে
For 15 years from 2006.
এবার অ্যাসাইনমেন্টটা দেখো কত দিনে।
Assignment হলো 2000 August 2018 assignment.
18 অ্যাসাইনমেন্ট, তাহলে 18 কতদিন ছিল? 36 সাল, ঠিক আছে। অরিজিনাল লিস্টটা 18তে মানে হচ্ছে তখন ওদিকে হ্যাঁ, ওদিকে 16 আর এদিকে হচ্ছে 2, 18 বছর, 15 বছর দিয়েছে, তো উইদিন দি লিমিটস দিয়েছে। তাহলে ভুলটা কোথায় গেল? ডিএম বসে আছে কেন? ইস্যু দি লাইসেন্স, issue the license. Everything is clear. What more do you want?
Right over the land.
Who?
They are right over the land. We want a single paper showing the right. They have.
No, most probably it has not been clear to you. That confusion was also in my mind. You think land belonged to Shivanidas home. Shivanidas executed a lease in favor of Numaligor. Now Numaligor executed a deed of assignment in favor of the Bharat Petroleum. Shivani gave for 30 years with effect from 2006. That is still that deed of license is in force. Now,
License, lease.
Now Bharat Petroleum has given a license to petitioner.
After Bharat Petroleum got the assignment, of the residual leasehold interest, Bharat Petroleum issued a license in favor of the appellant. Now, what further you want?
Previously, there was a writ. Prior to this writ, my lord, there was a writ, there was a direction upon the DM to conduct a inquiry with the interested parties and pass a reasoned order. In that writ petition, my lord, DM called this party and the landlady, everyone, all the interested parties, and there, my lord, the landlady has objected that she has nothing to do with them, and she doesn't
It's
know.
not required.
Not DM passed as such, my lord. The DM
Not
passed the reasoned order.
Milord, so far as I recall, Milord, when instructions came before me on behalf of the BPCL, Milord, two things cropped up. One, the land which was actually granted was recorded as Dhaba. Number one, the original land which was leased out. Second, physically where the retail outlet is located today was not the originally demarcated portion which was leased out. Now, Milord, on these 2 points, even today, Milord, as a matter of fact, although there is a license, the retail outlet is non-functional because of these discrepancies.
Okay.
So far as Milord, I faintly recall. Milord, I would only request, Milord, kindly takes it up tomorrow or day after tomorrow. I will, Milord, take out the instructions once again and appraise the court.
All
Where
the
is the
things are
difficulty?
lying before.
But there is a difficulty, Milord. I recall, Milord, I will appraise your lordship.
So the order they were asked to call for the agreement on the earlier writ petition, they were not even produced the documents also, which they are regarding, which I have produced in respect of the agreement. The agreement shows that lordship I am a licensee holder.
Just
And-
one day
and-
time, I will
and
appraise.
your lordship
There is a
kindly-
difficulty as
Mr.
far as-
Ghosh, more you open your mouth, the greater difficulty your client will be.
No, we have no difficulty. Milord, if they get a license, they will operate it. We have no difficulty.
Who was the in charge at that point of time of BPCL?
That I have to take instruction. I am not aware.
You have understood our hint? How did the assignment take place if the land is not demarcated? How did a public sector undertaking enter into the deed of assignment?
Let me come back. Milord, I will appraise. Milord, if there is any difficulty, Milord, I will let you know.
Mr. Ghosh, not before this court. Very difficult things. Not before this.
So regarding the NOC was also been given.
You see,
Lordship,
see, we have actually hold the brief on your favor.
Sorry.
আরে আমার একটা inspection এর কাগজ কোথায় যাচ্ছে?
Day after tomorrow করে দাও।
Day after tomorrow, Mr. Ghosh.
Copy, Milord, Baba.
You give copy.
Lordship, I will handle the copy.
Huh?
I have already been.
Give one copy with annexure.
Lordship, I have already by post. I have already been served.
By post you give, Mr.
I will give by hand.
Yeah,
Today. Yes.
By post you have sent to Bharat Petroleum Bhavan in Golf Grade.
No, it wasn't duly. It shows that it was been delivered to them Siliguri, territorial jurisdiction. এটা হচ্ছে 13 তারিখ duly delivered লেখা আছে হ্যাঁ if they seek I will give grateful Lord.
Number 7. Item number 7.
Wife of the original seller. Well, there was an application, at the post of the title have been under order for 27, but that has not been considered, lordship. Well, the stay application is there, lordship, page 51 is the application, lordship, under order 41/27.
Now tell us if again back to the same question. If in your plain there is no pleading, where is the question of allowing you additional evidence?
Only with regard to the wife of the original.
Madam, the difficulty is that we are hearing a civil matter. additional evidence can be given under Order 41, Rule 27 to corroborate what has been stated in the plaint or in the written statement. Now, in the plaint, there is no pleading. In the plaint, can you show us one single line that after the death of the original tenant, when his death was recorded and the legal heirs were substituted, can you show us any case being made out that as a spouse under 2G, I am entitled to stay for the for my life?
That there we got the entitlement of the legal heirs after the substitution, but not specifically with regard to the wife of the original tenant under section 2G.
See, this is a case under 1997 Act,
Yes, Your Lordship.
not a 56 Act. That the moment tenant dies, it becomes heritable. This is a case where the appellants, 2 sons and the mother is there, 3 sons. Now, so far as 3 sons, 5 years has expired. So they do not have any right. Now, so far as the mother is concerned, you have only the right. Now show us from the plain that you have pleaded that as a spouse, I am entitled to stay at the tenanted premises for my life. You show only this averment, will send it back for the limited purpose.
In the plaint, there is nothing, Lordship. The memo of appeal, it is in
See, memo of appeal will not help you out.
I cannot improve, Lordship.
So that's the end of the matter. That's the end of the matter.
Only with regard to the wife's deposition, Lordship. Only with regard to the since Lordship kindly consider.
Madam, I am giving you the judgments.
The
And I will, on that basis, I will dismiss your, because the court cannot take into account. Suppose you had laid this evidence, then also court cannot look into, because no part of the evidence which is in corroboration of the pleading can be looked into.
The application has been filed in the month of February 2023. That application, and that has not.
It is our incapacity to make you understand.
Yes, no, Lordship, I understood, Lordship.
Order 41, Rule 27. Suppose it has been, your case is that Order 41, Rule 27 was not disposed of. It was disposed of along with the main suit, main appeal. Now, madam, everything. What is the substantive law? If there is no pleading, where is the substantive law? কি বলবে বলো তো? আরে অর্ডার 41 Rule 27 দিয়ে কিছু হবে না তো, প্লিডিং এই নেই, তো আমি দেবো কোত্থেকে? অর্ডার 41 টাকে অ্যালাউ করে দেওয়া যেত, যদি ওর কোথাও প্লিডিং থাকতো তাহলে হতো। কোথাও তো প্লিডিং নেই, অথচ ইটস এ পয়েন্ট অফ ল। কিন্তু
Can lordship, Malord, what secure the ends of justice?
Which is the highest building in Jalpaiguri? No, which is the highest building in Jalpaiguri? How many stories?
I do not have a vast
In-
idea.
In Siliguri, which is the highest?
Siliguri, lordship,
পারবেন না দিতে। করবো
অর্ডার পাঠাতে এলাম that it appears no justified reason has been assigned as to why the court said substitute plaintiff being the wife of the first plaintiff did not adduce any evidence during trial. Ajit Kumar died during the recording of evidence of the plaintiff, then said did not adduce any evidence in the year.
Leading in evidence adduce করবে।
Cause of delay in adducing evidence at the stage of appeal had not been stated. In the year 2023, she intended to adduce evidence.
না, ডিকটেশনটা দিয়ে শেষ করি এটা, অনেকদিন ধরে পড়ে আছে। ফেলে রেখে লাভ।
She was some extent positive to allow that part lordship kindly consider lordship.
See, the difficulty is that discretion cannot be exercised in civil matters. Discretion can be exercised in a writ petition. You have to have a pleading. এসো। এই ওয়েস্ট বেঙ্গল প্রেমিসিস ফিন্সি একটা দাও তো।
পুঁজিটা বলবো, নিশ্চয়ই লেখা থেকে আছে। হ্যাঁ। কি করছে? ও না, তাহলে ফোনে দিতে It was not his case. His case, father of the petitioner was the tenant. Thereafter, after his death, plaintiffs have been inducted as tenant. These are fresh tenants. Plaintiff's name is Ajit Das and other.
No, Lordship. Plaintiffs' names are Surajit, Prashanjit, Shumit, and Dipalita Shitabai.
Okay, where is your case? It is not the case that.
Ajit Das and Ranjit Das, they are the brothers, they are the original tenant. Ranjit Das, unmarried.
This second appeal arises out of the judgment and decree
Dated 18th April 2024, judgment. And degree dated same.
কত?
Title appeal number?
না
At,
না 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 ডেটেড
Dated 18th day of April.
কেন এখানে কারেকশন করেছে তো
24. 18th day of April 2024. Judgment and degree of the appellate court.
হ্যাঁ ঠিক আছে 18th April 2004, passed by the learned District Judge Kuchbihar in title appeal number 25 of 2014. Full stop. The said title appeal arose out of a judgment and decree dated 20th May 2014, passed by the learned civil judge bracketed junior division, additional court, Sodor, Kuchbihar, by which the suit filed by the for where is the plaint?
Page 14 of the CAM 1. The stay application.
By which he will declaration and injunction filed by the tenant was dismissed. Full stop. The suit was originally filed by Ajit Kumar Das, the original tenant. Full stop. During the pendency of the suit, the said Ajit Kumar Das died, and as such, his 3 sons and the widow were substituted as the plaintiffs. Although when did Ajit Kumar die?
20th March 2012.
কি বললাম না না ওখানে কি during the pendency died or died intestate on
23/2012.
23/2012. With the death of the tenant, the suit which was filed after promulgation of the West Bengal Premises Tenancy Act 1997, in short WPTA 1997. The provisions of section 2 within small bracket G of the said act came into operation. Full stop. The three sons, being the substituted plaintiffs number 1, 2, and 3, on satisfying the twin conditions that they ordinarily resided with the tenant and were dependent upon him, had the right of residence in the tenanted property for 5 years. The widow, however, in view of the proviso to section 2G on satisfying the aforesaid twin conditions, had the right of residence till her life. Full stop. The on a perusal of the plaint, it appears that the right of the spouse, bracket a widow, being different from the other legal heirs of the deceased tenant, was not pleaded at all. The suit ultimately failed after the suit ultimately failed on contest. The trial court has recorded the reasons after analyzing the evidence while passing its judgment and decree dated 20th May 2014. Before the first appellate court, the appellants who are incidentally the appellants in this second appeal urged in one of its grounds. Where is the first memorandum of appeal in the first appellate court?
Start from page 46 of the stay application.
এই এসিটাকে একটু আস্তে করতে তো মাথা একদম জাম হয়ে যাবে।
We have touched paragraph number 5 and 6 of the waiver of that. A very little bit of that.
প্লেনটা কোন পাতায় বললে জান?
It is from 14. Page 14 of stay application.
Check for fine pollution against earlier. Eviction declare.
Bankim Kumar Das also died.
Bankim was the actual Bomkesh.
No, no. No, Ranjit Kumar Das.
Yes, that to Ajit Kumar Das, he is the brother and he is the unmarried issueless person.
আচ্ছা, ওইখানে একটু ভুল হচ্ছে ফ্যাকচুয়ালি, ঠিক আছে? ওই একটু প্রথম দিকে চলে যাও। হ্যাঁ, টাইটেল প্রথমে কি বললাম, ওর একটু আগে ইয়েতে না, উপর থেকে পড়ো না, যেখানে স্যুটটা বললাম অজিত কুমার দাস and Ranjit Kumar Das.
Died on 6th of October.
Yes, I've seen that. হ্যাঁ, কি বললাম? হ্যাঁ, the original tenants. They said Ranjit Kumar Das died on 6th October 2012. আর অজিতের তো ডেটে দেয়াই আছে, ঠিক আছে। তারপরে কি হলো? না, ওখানে দাও, ওইখানটাকে একটু ইয়ে করতে। রঞ্জিত কুমার দাস was at the, he was a bachelor,
Dying interest.
Was a bachelor and died intestate. Full stop. Ajit Kumar Das died by leaving behind his 3 sons. তাই তো পড়া আছে তো? হ্যাঁ, ঠিক আছে, এবার ওইদিকে চলে যাও, ঠিক আছে। হ্যাঁ হ্যাঁ, শেষ শেষ। ওইটা কবে? You said the first memorandum of appeal is in which page? Yes, madam, first memorandum of appeal of the first appellate court?
Yes, page 46 onwards of my stay application. Now, page 49, paragraph 5 and 6.
কি বললাম? Being ground number 6 as follows. ওটাকে সেট আউট করে দেবে 49 থেকে, full stop. The appellants also made an application under provisions of Order 41, Rule 27 for adducing additional evidence. ওটাতে দেখো তো ওই কথা বলেছি কি? Where is your Order 41 application?
Page 50.
Page 50 of the stay application.
51 Lord.
So what does paragraph 4 mean? 4, page 51. Yes.
That at the time of adducing evidence in this present suit, bearing 25 of 2008, your humble appellants could not adduce the prime witness, who is the wife of the deceased Ajit Kumar Das, nor cited any legal heirs of the deceased.
This portion not cited means
Not cited any legal heirs.
the plaintiffs were not examined.
Only one, my lord, who is that brother who died.
That brother Ranjit.
The Ranjit Kumar Das, only he was examined.
Oh, কি বললাম?
And after the examination, he expired.
Full stop. The ground on which the additional evidence was sought to be adduced, that the appellants, being the plaintiffs in the suit, could not adduce the prime witness, that is the widow, bracket appellant number 4 herein, and the legal heirs, that is the sons of the original plaintiff, Ajit Kumar Das. It is the case of the appellants that the first appellate court did not afford the appellants an opportunity to adduce additional evidence, and the said application was kept pending and ultimately disposed of, and was ultimately rejected along with the judgment and decree of the first appellate court. The appellants say that there exists a substantial question of law with regard to the right of the appellant number 4, being the spouse of the original tenant, a spouse of one of the original tenant, and also as to the rights of the appellants number 1, 2, and 3. Full stop. After hearing the appellants and considering the materials on record, we find that after the death of Ranjit Kumar Das, his brother Ajit Kumar Das, Ajit Kumar Das was his legal heir under the provisions of Hindu Succession Act 1956, under the provisions of Section 8 of the Hindu Succession Act 1956, read with the schedule thereunder. On the death of Ajit Kumar Rai, his sons, respectively being the appellant number 1, 2, and 3, had a right of residence to stay at the tenanted property on satisfying the twin condition that they were কি বললো?
The gift of Aditya Das, his sons, effectively doing operating minus 20 had a right of resident to stay at the community property on satisfying the following conditions that
They were ordinarily residing with their father, the tenant, and were dependent on him, as held by a coordinate bench of this court in the judgment reported in 2016 3 CHN 472. The appellants number 1, 2, 3, therefore, were therefore were required to adduce evidence that they resided with Ajit Kumar Rai in the same premises, in the tenanted premises, at the time of his death, and they were all dependent on the said tenant. Full stop. The appellants number 1, 2, and 3 have not taken this pain to adduce their evidence, though it was open to them on having been substituted as plaintiff pursuant to the death of their father, Ajit Kumar Das, on দেখো উপরে দেয়া আছে কত 2012 কত 20-3-2012 20-3-2012 ঠিক আছে
তোরা ফালা কাটায় তোরা থাকবি না বাড়িটা ডিলাপিটেড কন্ডিশনে সেটা কেউ ভাই গেছে
হ্যাঁ কি হয়
has not taken this pay, where is their evidence, though it was open to pay on having been certificated as plaintiff pursuant to the death of their father, Matas, on 8th March 2012.
We do not find any fault in the judgment of the trial court dated on 20th May 2015. As the trial court proceeded on the basis of the averment made in the plaint and the evidence adduced. It was also open to the widow, bracketed defendant number, appellant number 4, to specifically plead the exception contained in the proviso to section 2G of WPTA 1997 that she had a right of residence in the tenanted premises for her life. No averment was made by amending the plaint after she was substituted. The appellant number 4 also did not adduce evidence. Even though it is well settled that no amount of evidence can be looked into, dehorse the pleadings. Then also, if the appellant number 4 had adduced evidence, the trial court would have discussed the same. In absence of evidence from the side of any of the appellants, না কি বললাম ওর আগে
no amount of evidence can be looked into divorce, the pleadings. Then also, if the appellant of court have adduced evidence.
To satisfy the twin condition that at the time of death of her husband, she was residing with him at the tenanted premises and was dependent on him, and also did not have any other place of residence. Then the trial court would have discussed this issue. Full stop. We also do not find any infirmity in the judgment and decree of the trial court on this context. Full stop. Before that apart, and in any event, local inspection took place where the commissioner so appointed found that the premises in question was in dilapidated condition and the original tenants neither paid rent after 2002 nor did they reside thereat. The তারপরে হচ্ছে ওটা দেবে তারপরে ওটা ওই যে ইন দিস কনটেক্সট, তাই তো? এই যে একটা সেন্টেন্স বললাম না, হ্যাঁ, তারপরে কি না একটা ইনফরমেটিভ বললাম না, অনলি ইন দিস কনটেক্সট। হ্যাঁ, ওইটা পিছিয়ে চলে যাবে। আচ্ছা, stop. During the pendency of the appeal, the 5 years cap available under section 2G to the appellants number 1, 2, and 3 expired. The said appellants therefore lost their right to stay at the tenanted premises, even if they had satisfied the two twin conditions. The appellants number 1, 2, and 3 as on date, comma, therefore does not have the right available under section 2G because the 5 years time period commencing from 21st March 2012 had expired in the year 2017. So far as the appellant number 4 is concerned, in absence of pleading and adducing evidence that evidence to satisfy the twin conditions envisaged under section 2G of the WPTA 1997, and that she did not have any alternative residence, her right cannot be also looked into. At this stage, after return of concurrent finding by the trial court and the first appellate court, we also do not find any infirmity in the reasons given by the first appellate court for rejecting the application under section under Order 41, Rule 27 of CPC made by the appellants. The judgment and decree of the first appellate court is a well-reasoned one after minute appreciation of evidence laid before the trial court. The first appellate court has conferred with the findings of the trial court. In the aforesaid facts and circumstances, we do not find any substantial question of law for which the second appeal is required to be admitted. The appeal and the application for stay is therefore dismissed.
I have tried my level best. What can I do? Well, nothing is there. Just a one line. Nothing
After
is there.
2000,
See, I tell you, I have not, I may be quoting if I get the judgment of Justice Bhaskar Bhattacharya. Their substitution application during the pendency of the appeal was also rejected. Substitution made, application made by the two daughters. I'm forgetting, it is probably 2006 or 7 Calcutta division bench, on the ground that the 5 years period had lapsed.
Yes,
So
yes,
they do not.
petition case substitution cannot be done like this.
In the appellate,
Yes, yes.
I am not carrying all my
Grateful.
this is more a recent one, so I may not be getting it, but that is there. I am absolutely. It may be 2006 or 2008. The lady was the tenant.
Yes.
She had filed an appeal. Her two daughters were there. They were married daughters. The court went that in any event 5 years period has expired, so they do not have the right. If I get that, I will put that judgment also.
In eviction, substitution was not allowed. Yes.
Title appeal. It came in appeal before the court. In that, the division bench had given that fine.
Lordship, grateful.
Item number 8, under application of civil.
I appear for the opposite party in this matter, Lordship. I filed that substitute application, Lordship.
Yes.
Substitution application, Lordship.
Substitution application.
Yes, Lordship. Substituting কাকে করছিল? Respondent number 5, Lord.
What is the appeal about and what is the
Lordship.
What is the appeal about? What is the substitution?
Lordship, appeal about Lordship, preliminary declaring partition suit, Lordship.
Yes.
Challenging this appeal, Lordship.
Yes.
And yes, respondent number 5, Lordship. Respondent number 2, Lordship. Substitute.
You are appearing for whom?
For the opposite party, respondent number 1. All the respondents.
Serving a copy.
Lordship, I served through post, Lordship, to the substitute party, Lordship.
Yeah, maybe. What is the they have received?
No, Lordship, not effect, Lordship.
So serve him.
My advocate on record, Lordship, take a copy to you. My lord will keep it any as per your Lordship.
Mr. Kunaljit Bhattacharya, instructed by
Sottam Sarkar, Mr.
Sottam Sarkar, appears and submit that he has the instruction to appear to represent the respondents in this appeal. Let a copy of the substitution application filed by the legal heirs of the
No, Lordship, filed by the appellant, Lordship.
sole appellant has filed it.
No, appellants, Lordship.
Appellants.
Filed by the appellants. হ্যাঁ কি জানি কি বলছো বুঝতেই পারছি না
No, Lordship, the respondent number 2 has died, Lordship.
Respondent number 2 has died.
And legal, my lord, appellants legal were also substituted.
Go to the elaborate.
হ্যাঁ,
কি বললাম কি বললাম না filed by the appellants to implead the legal heirs oblique heiresses of the
respondent number 2
respondent number 2
since these
who died during the pendency of the appeal be served on such and such a Sottom, particularly in view of the fact that the copies of the application sent to the respondents have not yet been received by them. Let this matter when? Tomorrow?
any day, yes, tomorrow.
Lordship, they have any, Lordship.
Tomorrow.
Lordship.
Yeah.
আমার তো objection নেই, আমি তো নাম দিয়েছি।
ঠিক আছে।
Grateful.
Grateful, Lordship.
হ্যাঁ, নাম দিয়েছি।
Item number 9, under application civil.
I'm for the appellant.
Yes.
My lord, this is an appeal which my lord had heard previously, my lord, wherein the appellant is a scheduled tribe member and a decree has been passed under the Hindu Marriage Act, my lord. Decree of divorce has been passed under the Hindu Marriage Act, my lord, and that has been challenged before this court, my lord. Already, along with my appeal, my lord, I've also sought for an interim maintenance, my lord, since the filing of the appeal, my lord, the respondent husband is not giving any payment, any maintenance to the wife. That the Mr. Poddar had appeared and sought for some adjournments on the last day.
Yes, ma'am. I sought for adjournment. My learned friend is online trying to reach. I want to take an.
May it please, your lordship.
Yes.
May it please, your lordship. My lord, I'm appearing for the respondent here. My lord, here I would like to file my response because there is a material instruction which has been suppressed in the petition itself, my lord. The respondent voluntarily has been paying 11,000 per month, my lord. Even in the last month, even in the current month also, it has been paid.
Oh my lord,
There's not a single avertment in the application that the respondent is paying and the petitioner is receiving money.
I admit that.
Just a minute. It will be a suppression only if you can satisfy that yes, month by month you have paid her. Unless
absolutely, my lord. That's what, my lord. That's why, my lord.
Where is the document?
No, my lord. Therefore, I would request your lordship to grant me 2 weeks time to file my affidavit in response along with all the bank statements, my lord, because the money is transferred from bank account.
These are old school thought. Sorry, you first show us that you have paid. If we are prima facie satisfied, then only we'll go to the next stage. Just on your
in fact,
just oral submission. Your oral submission that to virtual mode, no, nothing doing.
In fact, the statement of accounts is there with my colleague, my lord, who is appearing physically. It has been sent to him. The statement of accounts clearly indicates, my lord, every month the money is paid from the bank account, from the respondent bank account to the petitioner's bank account.
Show us. So this month's payment. This month's payment, kindly ask them to show me. if they have paid.
Now, whether previous month he has paid.
My
or
lord,
not.
till we have filed the appeal, till it was heard, he has paid. For last 3 months, my lord, he has not. He stopped paying. And now when one of the mediator
You
who had,
pleaded this fact that he was going.
No.
Making payment.
My lord,
But
that
for
have,
the last 3 months, he has not paid.
no, after, when I was filing, my lord, that have pleaded, my lord. I had my,
অ্যাপিলটা তো অ্যাডমিট হয়েছে অ্যাপিলটা কবে কবে ফাইল করেছে
Well, this is an application filed on 31st of July 2024.
24, my lord.
24.
That
1
time
year
it was
back, my lord.
paid. But my lord,
No, my lord.
recently 3 months, my lord, she has not been receiving.
Your lordship will
That's
kindly
why I have pressed upon this application. Otherwise,
peruse the,
not have
my lord,
pressed.
my lord will kindly peruse the
Ask
application,
them
my
to
lord.
show
There
them
is
the
one
payment of
note.
this month, my lord. If they have the
My lord,
statement, this month's
let
payment.
my learned friend
They were,
show
my lord,
one
the
single
agent
statement
went
from
to,
the application. my lord.
tell them like kindly give the money. She is in a problem. They abuse that persons and send them. We have nothing to do with her. The decree has been passed in a very abusive manner, my lord.
Oh, okay, later on.
My lord, the last payment was made on
So
13th
the
of June, my lord.
respondent is an employee. Is an employee of which department?
আর্মি
You are army.
Army, my lord. He's
the
an
matter
army,
was
my lord.
taken
Now,
up, my lord.
currently, my
13
lord.
After
In fact,
that,
your
it
lordship
had
will kindly appreciate one thing, my lord. The respondent is a cancer patient, my lord, undergoing treatment from last 3 years. He has undergone 3 surgeries. And despite, my lord, there is no order for paying maintenance, my lord. Voluntarily, the respondent, even 13th of June last month also payment has been made. 13th of June. My lord, your lordship will kindly see, my lord, let my friends show one avertment in the petition that the payment is being done and they are receiving and not being paid. One avertment at
it's not
F, my lord, will kindly see.
Okay.
the averment will not be there because it is the case of the respondents that you had been paying but for last 3 months you have not paid. That is the case they are running. It is the case that for last 3 months you have not paid.
No, my lord, that's not what is pleaded in the application, my lord.
When was the
No,
application
your
filed?
lordship will kindly appreciate one thing. This application was filed on July 2024.
So
July
that
24.
cannot be a
So
pleaded
at
case,
that-
my lord, that last 3 months it has
at that
not been paid.
in July.
On 31st of July 2024.
Yes. So at that point of time you were paying. He did not say anything.
I did not press my application.
No. My lord, this the July 2024, if that point of time, my lord, I was paying in the last 3 months, even, my lord, I have handed over the statement of accounts to my friend appearing physically. That clearly shows, my lord, 13th of June 2025, 11,000 was again paid.
Show us.
My 30 that day,
The last
my lord
statement, my lord.
had heard the matter on the previous date, my lord. And my lord, they had fixed on Monday. My lord, if that payment is subsequent to hearing of this matter, I will confirm if that has received, my lord. But if that is being paid, that is after hearing this.
This, my lord, this statement or account of 13th of June 2025.
The last current. He was taking instruction from client whether payment has been received to the bank.
That I'll understand. But my lord, kindly sees 13th at the end of the day, my lord. That means, my lord, when I have pressed this application, they feared. That's why, my lord, they have paid it. My lord can
That's
understand.
an
this
assumption,
very
my
well,
lord.
My lord kindly directs them to pay me monthly every month. But I have no
Is there under the decree? Is there any?
no aluminum.
No, my lord. There is nothing.
Why?
My lord, the decree, my lord, if my lord goes through, they have said that I have lodged certain complaints against them that I could not be able to prove. On that ground, the order has been passed. But no maintenance has been granted. The court has also not considered whether the maintainability of their application under 13, while knowing that my client is a scheduled member tribe. Even the respondent is a scheduled tribe member.
There is a direction for
Tenancy of the
my lord, there is a direction for paperwork for final hearing, my lord.
Have you prepared application under section 24?
My lord, 36. Special Marriage Act
Or special marriage, you filed application.
in this court, my lord.
The trial court granted it, added to.
No, my lord, at that time, my lord, the voluntarily the husband was giving
How much?
10,000, 11,000 rupees.
11,000.
Yes, my lord. There was an, in police station, my lord, there was a mediation between the parties. After that, that amount was set, fixed, she was receiving, my lord. So for that purpose, she never approached 125.
Yeah.
So you are paying that amount, are you satisfied with the amount?
My lord, if it could be incremented little bit.
Well, increment,
Then, my lord, it's been a long time, my lord. 11,000,
So
my
you
lord.
are paying that amount?
I am paying, my lord, I am
You
paying.
are voluntarily paying?
Yes, my lord.
Eh?
Let that be recorded, my lord. They'll continue to pay till the disposal
They
of.
will continue to pay.
I am paying.
You are paying even in absence
My
of
lord,
an
another
order
thing, my lord,
from
there
the
is a,
court.
my lord, there is street for direction till today.
Absolutely, my lord.
Paper book not prepared, my
My
lord.
lord, I
Kindly
received
hear the
notice, it
final
is
thing,
being
my
prepared.
Ah, yes, it will
My
be
lord,
hard.
my lord,
Don't-
kindly,
it
my
will
lord.
be
Heard
hard.
today also, my lord. It's a
See,
simple point of law.
See, we have a basic, this thing, a point over here.
My-
The basic point is whether the court exercise proper jurisdiction or not. Because if the lady is from scheduled
Right.
caste, scheduled tribe, then
Yeah, my lord.
you are in difficulty and don't go by this way.
No, no,
You know the scheduled tribes, scheduled caste atrocities act.
1890.
Then where will you go?
No, my lord, I am paying, I will pay,
You
my
will-
lord, I have
you
no
will
problem,
instant-
kindly
You
hard.
will instantly lose your job. You will instantly lose your job. Staying in classroom does not suggest
No, no.
throwing pellets outside.
I am paying, not so much, payment was also done. But then,
Then what?
kindly direct to submit the paper book and.
Ah, yes.
Like
If
this.
they cannot, you file paper book.
No,
The-
there's
the
a
allow-
petition
this is an
on-
application.
Maybe you want to.
No, upon the petition on-
This is an application by the wife for inter alia for inter alia for interim maintenance pendentility and
Expenses of the proceedings.
expenses of the proceedings, full stop. The appellant says that she belongs to the appellant bracket a wife says that she belongs to scheduled tribe community and as such the and as such the decree annulling the marriage granted to the respondent in his suit under Hindu Marriage Act.
Yes.
Hindu Marriage.
Under under section 13 of Hindu Marriage Act 1955 is without jurisdiction. There is prima facie substance in the submission made by the appellant about the applicability of the law for annulling the marriage between herself and the respondent. Full stop. The first appellate court, no, first, the trial court, while granting the decree for dissolution of marriage, has not granted any maintenance either in interim or on permanent basis. Full stop. It is, however, the case, the case of the respondent husband that he has been voluntarily paying a sum of rupees 11,000 per month to the appellant towards her maintenance and cost. Full stop. On a query from court, it is submitted by the appellant, which is not disputed by the respondent, that on the basis of a mutual agreement arrived at before the local police station, this amount of rupees 11,000 per month was being voluntarily made by the appellant. The appellant, however, says that no independent income. এটা কেটে দাও, এটা কেটে দাও। কি বলবো, appellant বলেছি। Appellant, however, says that for last 3 months, no payment has been made. As a consequence whereof, the appellant has been compelled to move this application, which had been filed as far back as on
31st July 2020.
As far back as on 31st July 2024. Since she was getting the maintenance, she was getting rupees 11,000 from the respondent to sustain herself. On behalf of the respondent, it is submitted that he is suffering from carcinoma and has undergone surgery, as a consequence whereof there was a delay in paying the amount of rupees 11,000 for a couple of months. Full stop. After hearing the parties and considering materials on record, we find that the respondent is an army personnel and the appellant does not have an established personal income to sustain herself. in the aforesaid facts and circumstances, till the disposal of the appeal, the appellant shall continue to pay the said sum of rupees 11,000 per month, month by month, within 10th of each month, till the disposal of the till the disposal of the appeal. Full stop. Although, comma, there is a direction for preparing the paper books by the department, and it is the allegation on behalf of the respondents that the appellant is not taking any steps to have the paper books ready. Let the paper books be made ready as expeditiously as possible. The respondent shall be also at liberty to approach the department and comply with the requirements for getting the paper book ready. Once the paper books are made ready, the parties shall have liberty to mention the appeal for being enlisted for hearing. Full stop. Nothing further remains in the essay.
You pay certain amount for expenses of the proceedings.
But at this stage,
As
if your
advocate
lordship is
gave something, it will be finally decided.
Otherwise, the paper will never get ready.
I understand that, but your lordship will also have a kind consideration towards the health of the petitioner, my lord, who has been incurring expenses in the cancer, my lord.
Very well.
My lord, in fact,
in fact,
with your lordship's permission, may I just clarify one thing, my lord?
Yes.
With your lordship's permission, can I clarify one thing, my lord? Lordship has recorded that there was a delay in months, my lord, in payment, making the payments, my lord. There was never default in any months, my lord. Every month it was paid. Maybe days are here and there. Days are here and there.
Delay, that's the delay.
But
we have not recorded
lordship,
that.
Lordship,
You have not recorded
lordship
that.
recorded as lordship recorded as default in months.
No, not default.
Delay in months.
Delay. We have not said default. I am conscious in the choice of words.
I absolutely oblige, my lord. My lord, in fact, my lord, your lordship will kindly appreciate, my lord. At this stage, my lord will not grant any expenses for the proceeding, my lord. Your lordship will.
The advocate, they are engaging the advocate. They are to prepare the paper book. You consider.
My lord, let my expenses record. Let my expenses record before your lordship, my lord.
The respondent shall also pay a sum of rupees 15,000 on account of cost of proceedings to the appellant by 15th July 2025. Nothing further remains to be adjudicated in this application. Cancer also is accordingly disposed of.
That you take decision. Your association, your wife is at this stage is very much required.
I'm obliged.
You consider your decision.
Yes.
You are suffering from carcinoma and such and such.
Grateful, my lord.